We are live and recording.
Good morning, everybody, and welcome to the April 17th meeting of the Committee of BARS members. As a reminder, this meeting is being recorded. This time, Devin, please take the roll.
Bolton, not present. Burns,
Present.
Cow,
Here.
Bengora, not present. Kaplan, not present. Kramer,
Here.
Lauren,
Here.
Lee, Macy-Walla, not present. Montgomery,
Present.
Reed, not present. Reyes,
Here.
Reyna,
Here.
Silva Guzman, not present. Smith,
Here.
Yokelson.
Here.
We have a quorum.
Thank you, Anna. If I didn't say so before, testing 1, 2, 3. Sorry, folks, we're playing with our volume here. I'm calling this meeting to order, and I'm going to turn off my mic. Okay. We have three. We have three members appearing remotely today. Is it me?
I think it might be our mic.
Am I saying something wrong? Okay. As I said, we have we have three members appearing remotely today. As required by the Bagley-Keene Open Meeting Act, members appearing remotely must appear visibly on camera, except if a member is unable to appear by video due to connectivity challenges. If that is the case, please provide an explanation. Members should also raise their hands when leaving and returning to the meeting if they will be absent for more than 5 minutes.
Correction, just two members are now appearing remotely.
Two members are appearing remotely. And I'm sorry, folks, we're having audio troubles here. First up on the agenda is a call for public comment. Before we begin with the comment, I would like to remind everyone that under the Bagley-Keene Open Meeting Act, public comments must pertain to the items that are on the agenda or be related to matters that are within the jurisdiction of this agency. Specifically, the committee exercises oversight on admissions matters. Discipline matters on the agenda for today's meeting. Members, we can't. Members of the public, okay.
Use the handheld mic.
Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . Tom? Okay. Would have time to consider these comments. The committee has received and read all the written comments. We thank you for that. To facilitate hearing as many members of the public as possible, I encourage you not to repeat points that were already made by previous speakers. We do have a full agenda today, and we will be recessing this meeting at noon for the subcommittee on testing accommodations and eligibility meeting. We will return to complete the CBE agenda at the conclusion of the subcommittee meeting. As a result of these time constraints, I'm going to exercise the option to limit each speaker's time to 2 minutes or to close public comment period after 2 hours, which includes a 10-minute break or after the first 100 speakers, whichever occurs first. For those who are participating by Zoom, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom center of your screen. If you wish to address the committee, please click on the hand icon now, and the committee coordinator will call on you in the order that the hands are raised. For those that are participating by phone, you may virtually raise your hand by pressing *9. That is the star key, then the number 9. Doing so will alert staff that you would like to make a comment and that the committee coordinator will call upon you and open your microphone so that you can address the committee. For those who are participating from a notice location, please alert the committee member or the State Bar staff member present in the room if you would like to comment. Staff will have an on-screen countdown timer visible to all attendees during the duration of your public comment. The timer's 2-minute countdown will begin as soon as you start your comment. The on-screen timer will flash throughout the last 10 seconds. We will start public comments with people who are in person, starting with anyone at any of our remote locations. Then we will move to those who signed up in advance. The committee coordinator will now call on members of the public who are in person at any one of our remote locations. Are there any, Devin?
We do not have any members of the public in the San Francisco office.
All right. At that, and then let's go with the advanced sign-ins. I think our first person is somebody we know well, Alex Chan.
And I'd also like to note for the record, Vice Chair Ashley Silva Guzman has joined the meeting.
Welcome, Ashley.
Our first public comment is from Alex Chan.
Thanks, Evan. Hi, this is Alex, former chair of the CBE. I want to say I miss each and every one of you, the staff and the committee members. And with that, my comments are directed to agenda item 4.7. Your vote today goes far beyond choosing an exam. It raises bigger policy questions about portability, reciprocity, and how California will define and assess minimum competence. Those are foundational issues, and that's why they have been closely studied by the Blue Ribbon Commission. But it's really also important not to lose sight of the California Supreme Court in this process. The court has already spoken on these issues, and that guidance should remain front and center. And if the committee is considering a different path, the rationale should be clear, careful, and firmly grounded. Now, the committee serves as a steward of the court, and that role requires caution before advancing any recommendation that may depart from the court's prior direction and guidance, particularly where preserving the court's trust and confidence is essential to the committee's work. And when the bar exam graders, 63 bar associations, and even professors who specialize in licensure and bar reform have come out opposing the adoption of next gen, the issue really calls for more and not less careful study and thorough analysis. That doesn't mean the answer is automatically a no. It simply means more time is probably needed to fully understand its potential impacts. And the public deserves that. And remember, there is a practical lesson here. Last year's bar exam showed us exactly what can happen when major decisions move way too quickly without enough testing, evidence, or even caution. And remember, public confidence is hard to build and easy to lose. And if a recommendation would have been made today, it's important to keep the court's guidance and public opinion fully in view. With that, I thank the committee for your time and your thoughtful decision. I missed you all, and I look forward to seeing you all in the new term. Thank you, Chair.
Devin?
Our next public comment is from Nadine Mazard, who I do not see in attendance. Next, we have Gil Pellis.
Hello. I am the co-chair of the Los Angeles County Bar Association Future of Lawyering Committee. I'm speaking on item 4.7. LACBA submitted a letter signed by 63 bar associations strongly urging the board and CBE to take the cautious approach and not make a long-term decision until 2028, when you will have performance data on the NCBE Next Gen exam, the Nevada exam, which may be superior to Next Gen, and more information on all options. I will repeat that again. 63 bar associations united on this view, representing the vast majority of practicing attorneys in the state. I will read just a few of the 63 bar associations that joined LACBA's letter. Virtually every county bar association in the entire state, LGBTQ plus bar associations, prominent minority bar associations such as the Black Women Lawyers Association, the Mexican American Bar Association, the Asian Pacific American Bar Association, and many more. Women lawyer groups, consumer attorney groups, plaintiffs' lawyers, defense lawyers of all practice areas united on this view. Before rushing into a long-term decision, you owe the profession and public due diligence to cautiously wait for additional data and get this right. And especially when, according to the staff report on page 14, the State Bar's own experienced California graders who beta tested the Next Gen exam says it does not test minimum competency as well as even our current exam and are threatening to quit if Next Gen is adopted. This is a shocking warning by our own unbiased graders that should sound an alarm and give us pause. There is no upside to rushing into a decision without due diligence and demonstrative data. There is no upside in rushing to abandon key California legal topics, such as community property or California ethics, which will cause law schools to stop teaching them. There is no upside to adopting an exam that the State Bar's own experienced graders called substandard and will cause them to quit. California should lead the nation and demonstrate that it will make the right choice after careful deliberation. If we get this right, other states will follow us. That choice will be clear by 2028. Thank you.
Our next public comment is from Jessica Jacobs.
Can you hear me?
We can.
Okay, thank you. And you've probably heard the quote, "Injustice anywhere is a threat to justice everywhere." But what if you hear the quote often, "Don't bite the hand that feeds you"? And what if that hand is the very source of the injustice? I hired an attorney to help me with my moral clarification after an inappropriate referral by this committee, an expensive $5,000 I did not have, and her advice was simple: sit down and be quiet. Don't bite the hand that feeds you. The bar has it out for you because you're holding them to the very laws they're supposed to uphold. This might be practical, strategic advice, but it's not why I've done this journey. I did not pursue the law to be managed or muted by power. My moral character application is unstained, but for the erroneous referral from the very committee tasked with judging it. The irony is not lost on me. I am an author with a highly acclaimed book on the very topic of character education and universal virtues. Integrity and fairness define me. So I will continue to speak up, not to bite, but to insist that the hand itself follow the law, which it has not in my case and likely in many others. This committee denied my request for a 2-week extension of an unpublished and arbitrary deadline for a signature. In the very same month, your moral character division missed the statutory deadline in my case, and your general counsel requested of me additional time to respond to my Supreme Court petition, which, because it's the right thing to do, I agreed to. I ask this plainly. Why is flexibility unavailable to applicants, yet readily available to the institution? There was good cause for my request. As far as I can see, it wasn't even addressed. Meanwhile, the bar's own missed legislative deadlines were somehow totally fine, and I hope that brings you embarrassment. If character and justice are the standards, they must be modeled as well as measured. Thank you.
Our next public comment is from Marcia Griggs.
Good morning, and thank you all. I want to share that I am a tenured law professor, full tenured law professor at St. Louis University School of Law, whose scholarly agenda includes licensure assessment and specifically bar admission. Today, I urge the committee to refrain from immediately adopting the Next Gen bar exam. The academic community of which I am a part is not fully united on the effectiveness of this exam and its ability to test minimal competency. And that has been the case since the introduction of multi-state and uniform exams, right? I hope that the committee, before making a decision, would seek input from the Association of Academic Support Educators, who specialize in this area. It's an association led by Professor Nachman Gutowski before making a decision, who could give you possibly a more balanced and informed perspective on this issue. I understand that there may be a push from some vocal advocates at California law schools to adopt the bar exam, the next gen exam, and there certainly are some advantages to that. But I hope the committee would weigh any such push with due measure. While portability is important to law schools because it does benefit graduates who often are in big law or have the resources to be licensed and practice in multiple jurisdictions, portability is not the gold standard for bar assessment, and it does not serve to benefit your individuals without resources who are in legal deserts in your state. It is those individuals who would be practicing there, hanging a shingle as sole practitioners, who need the most guidance and the most rigorous exam to protect the public. Portability, moreover, can be accomplished through measures other than any type of uniform exam. Right? The simple fact is a gold standard cannot be confused with a monopoly provider. Right now, we have one single provider, and California has an opportunity to be a leader. And I want to see California lead or join another jurisdiction like Nevada and use its exam. Thank you.
Thank you, Professor.
Our next public comment is from Edward Reyes.
Good morning, Mr. Chairman. Good morning, members of this committee, and I wish you a happy Friday. My name is Edward Reyes. I am a licensed attorney. I'm also a former teacher, and I also operate Jurex bar preparation. I can predict one thing here. I can predict. I can look at July 2028. I can tell you right now which school is going to do great, no matter which exam is tested. And I can tell that based on the parents' income of the students of that school. That is a practical aspect. That standard of measure applies for public schools and private schools in California and the United States. And that's the elephant in the room. No one talked about that. And bureaucracies, public school systems, and the state bar don't focus on that either. So what do they focus on? They focus on relevant studies, and they produce fancy reports to meet their objectives. So there's a practical aspect and there's a bureaucratic aspect, which are fancy reports. Here, the state board has neither. You don't address the practical aspect, and you do not address the bureaucratic aspect. And the reason why is because NCBX does not have full studies on Gen X, because those exams have not been implemented as of yet. And also, someone mentioned the dog. Don't bite. Actually, they said don't bite the hand that feeds you. Well, let's talk about bites. Let's talk about dog bites. Let's talk about the one bite rule legal doctrine. The state bar has already expired. It's exhausted. It's free pass because of the fiasco with measured learning. So let's not do that. Let's wait for the results and let's make a decision then in 2028. Thank you very much.
Thank you.
Our next public comment is from Viviana Barneswell, who I do not see in attendance. Next, we have Jewel Sarkar. Jewel Sarkar, you've been unmuted.
Let's move on and then you can come back.
That concludes our advanced signups. We'll now move to members of the public wishing to provide public comment remotely. We have Benjamin Cohn.
Mr. Cohn, you are recognized for 3 minutes.
Thank you. I wanted to start with the rationale given at the last meeting of who's going to be responsible when the exam gets messed up. And it does seem to get messed up in some way or another every exam cycle. There was commentary by staff that an advantage of Next Gen is NCBE will be taking the blame if they mess up. Now, the meeting before that, the same point was made, I forget by who, and CBE member Paul Kramer had said he didn't know that that was true, in that it would be just as likely that you would get the blame as if you'd done it yourselves. I disagree with a lot of what he's been saying on this issue of which exam to pick, but on that point, I think it was spot on. The picking the NCBE is not going, and having them administer this for you is not going to absolve you of your responsibility to the public and to the applicants for a fair exam that is operationally smooth. The decision to switch to Kaplan in the first place was not made lightly. Before the events of February 2025, largely caused by Measure Learning, not by Kaplan, there were a lot of causes besides the ones that I've been most focused on that made staff consider NCBE to be infeasible, and those aren't going away. Even if the NCBE tries to posture that they will do things differently now, because they're a monopoly, they can bait and switch you. They can get you to build dependence on their data sets over decades, claim that you can't scale it without them, and hold you hostage to, just like they did, for example, during COVID, when it first came in 2020, when they said that their exam integrity and business interests outweighed public safety, and they were for months telling applicants they wouldn't even allow a remote exam, and they never gave their full exam remotely, only scrap questions they wouldn't help scale. There were a lot of reasons, and who's to say if they're cheaper temporarily, they won't raise the prices once you're dependent and locked in. The greater threats are to quit are a major red flag that's new. There are a lot of reasons to believe the NCBE will mess this up, that you will get blamed, and just so you know, the ADA liability is vicarious for what they do. Thank you.
Thank you.
I'd like to note for the record that CB member Dr. James Bolton has joined the meeting.
Welcome, Doctor.
Our next public comment will be from Ray Hayden.
Hi, asking if you can hear me. I sent in comments beforehand, so let me just jump on the one I want to focus on here. Is the number one, fiscal integrity, the $7 million plus discrepancy. The hidden taxes, current staff projections omit the mandatory $149 NCBE technology fee, and this is a direct tax on applicants totaling over $7.1 million over the projection term. The cost benefit failure is when the fees factored in. The Kaplan proprietary path is significantly more affordable for the applicants the state bar is charged to protect. With that, I want to remind you, I, Florida man himself, am indeed a member of the general public and society as a whole. You need to protect me too from your exam. You have in your hands, your hot little hands, you have a fantastic psychometrician that you have hired previously to help you figure things out. Her name starts as Tracy, and I believe I have her right last name as Montez. She is a high-flying professional in the state of California. She agrees that the actual multiple choice only licensing exam that I've been suggesting to Donna for years is an absolutely positively correct way to go to meet and exceed all of California bar's hopes and dreams. One more thing, there's a gentleman sitting with Dr. Michael Cow. I apologize for not remembering your name off the top of my head. I apologize, sir. You've been doing incredible work. I've been watching for you you since you first popped in, and you guys, Donna, that gentleman right there, and a whole bunch of other you people came massively close to pure perfection on that February 2025 screw up. You were doing great things. You were doing great things in a great way, and you almost got it. Okay. You were very, very close. Feel free to contact me. Talk to you later. Have a great meeting. Bye.
Our next public comment is from Edmund Arufo.
Hey, good morning. My name is Ed Arufo. I'm a retired Navy officer, and I'm also a licensed attorney here in California. I run a firm with one other attorney. We're carrying about 230 cases all the way from San Francisco to San Diego. I've also taught courses at the bachelor's level and at the doctorate level, and I run a small bar prep examination program. I carry about 1,000 students a year. One of the courses I've taught at my law school was federal criminal practice, which required the writing of motions. This is a writing class, to be sure, and I've seen the quality of writing not only there, but within the bar prep program as well. To be absolutely clear, I think we as educators need to do more to improve the writing of our fledgling attorneys. Not less, but more. It's our core competency as attorneys. Our written words persuade, they paint pictures, they illustrate, they bolster the arguments of our clients, and we can't do our job without this core skill. I've said it in my class many times, writing allows us to communicate with the living, the dead, and the yet unborn. It's absolutely critical to providing competent representation to our clients. Absolutely critical. And it's fundamental to the noble profession of lawyering. I'll be taking the next gen exam in July myself, only because I think it'd be hypocritical to try and teach an exam I haven't passed myself. But from what I can tell as I prepare for the exam, it doesn't force the improvement of writing. Instead, it takes a step backward. I firmly believe this is the wrong direction to take. It moves in the direction of what we've learned through the youngsters nowadays, where texting is just a small amount, LOL. That's what we're doing with Next Gen. As Alex Chen mentioned, we've seen the February 2025 disaster, and we should have learned already. We should have learned. We have time and options to continue what we're doing. In the interim, the only logical position I believe that we should take is to wait and see. Let's see how this develops. Let's be smart about how we go forward. Thank you for your time.
Next, we have Jules Sarkar.
Am I working now? Thank you very much. My name is Jules Sarkar. I'm calling in to urge this committee to slow down the considered proposed recommendation to adopt the next gen bar exam before it has even been deployed in any jurisdiction. As you've seen from the meeting materials, there are threats by California bar graders to quit grading if the next gen bar exam is adopted, and it's not really a surprise why they would do that. The NCBE has long been confident in its ability to not do certain things, including developing exam software. Now, I've included, it's only mentioned briefly in my comment in a couple sentences, that about over 15 years ago, a blind applicant sued the NCBE asking for the reasonable accommodation of just using existing software to help her. And they said, no, you can't be a lawyer unless you use this number 2 pencil and use our bubble sheets, or you sue us all the way to the Ninth Circuit Court of Appeals. And she did just that. It took her 2 years of litigation. She got that court order. That was 15 years ago. And even then, even after they were ordered to do that, they still resisted using any kind of technology because they were confident in their ability, that they didn't have the ability to do what they're going to do right now with the next gen, or they claim they're going to do. So I urge this committee to reconsider. If you're concerned about what happened February of last year, remember this is something that the NCB has never done before, and they have long been confident in their ability not to do it. Just at the very least, stop and wait to see how this plays out in other jurisdictions. They haven't even deployed it in a jurisdiction for the first time. Thank you very much.
Next, we have Alfredo Hernandez.
Good morning, State Bar Committee members. I'm Alfredo Hernandez, Executive Director of the Sonoma County Bar Association. I'm here to speak on item 4.7. In an effort to save time, I would just like to piggyback on my colleague Gil Pelly's comments. Sonoma County Bar Association stands with the 63 Bar Associations statewide that urges the committee to take a cautious approach and not make a long-term decision today. Thank you.
We do not have any additional raised hands.
Thank you. Thank you, everybody. The committee recognizes the import of the decisions that we'll be making in the next few months and the recommendations to the State Bar. And we really want to thank members of the public who made for these comments and for this input. It is being considered very seriously. With that, let's go to the items on the agenda. Item 1.1. The first item is the chair's report. Since CBE met just about a month ago, there are only a few updates to provide. The period to submit a proposal for CBX software delivery program closed this past Monday. We received 5 proposals. The exam administration subcommittee will be considering these proposals in the coming days and weeks. We are on track to release, and then second of all, we are on track to release results from the February bar exam on May 1st. So May 1st, put that on your calendars. Over the next several weeks, staff and I will be interviewing candidates who applied for appointment to the CBE. Under the rules and procedures in place, our recommendation will be presented to the board's appointments liaisons, who will then consider them and advance final recommendations to the Supreme Court. The court may select from the list provided, but is not required to. The court typically announces these appointments in late August. And that concludes my chair's report. Next item on the agenda is item 2.1, approval of the minutes from the Committee of Bar Examiners open session on March 13th, 2026. Does anybody have any comments on the minutes from that meeting? Seeing none, is there a motion to approve?
Is it Mike? I'll make that motion.
Okay. Actually, Dr. Cow, Dr. Bolton beat you to it. So Dr. Bolton moves. Dr. Cow, will you second?
Yes.
Dr. Cow, second. Devin, please call the roll.
Bolton,
Yeah.
Burns, Cow,
Yes.
Gongora,
I'll abstain.
Kaplan, not present. Kramer,
Yes.
Lawrence,
Yes.
Lee, Macy-Walla, not present. Montgomery,
Yes.
Reed, not present. Reyes,
Yes.
Reyna,
Yes.
Silva Guzman,
Yes.
Smith,
Yes.
Yokelson.
Yes.
With 12 ayes and 0 nays, the motion carries.
Thank you. Let the record show that committee member Kareem Gongora has arrived. Welcome, Kareem. Long flight. Next on the agenda is a consent calendar. There are 3 items on the consent calendar. Did I skip?
Yeah.
Whoops. Whoops. I'm sorry. Approval of the minutes from the joint Board of Trustees and Committee of Bar Examiners open session minutes. So as you'll recall, we had 2 meetings last time. These are the open session meetings from minutes from that meeting. Are there any comments on that? Do I have a motion to approve?
Kramer.
Kramer moves. Second? Anybody second? Judge Reyna seconds. Devin, please call the roll.
Bolton,
Yes.
Burns,
Yeah.
Cow,
Yes.
Gongora,
Yes.
Kaplan, not present. Kramer,
Yes.
Lawrence,
Yes.
Lee? Masiwala, not present. Montgomery?
Yes.
Reed, not present. Reyes?
Yes.
Reyna?
Yes.
Silva Guzman?
Yes.
Smith?
Yes.
Yokelson?
Yes.
With 13 ayes and 0 nays, the motion carries.
Thank you. Now, next on the agenda is the consent calendar. There are 3 items on the consent calendar: administrative updates regarding law schools, action on requirements for California accredited law schools and unaccredited law schools to require courses requiring the competent use of artificial intelligence, and the status update and action on the Committee of Bar Examiners work plan. Do any members wish to pull any of these items off the consent calendar? Mr.
Yes,
Kramer.
Work plan, I just have a couple questions.
Okay. Go ahead.
So a while ago, when the court wanted us to hire a rules attorney to sort of unify our approach to all the rules, work on all rules stopped for about a year. That person was hired and has since left, as I understand it. Are we going to have another stoppage?
So we don't anticipate a full stoppage. The Office of General Counsel is reorganizing its staff reorganizing its staff assignments. So there probably will not be, in all likelihood, a single attorney, rules attorney assigned to review the rules, but they will assist us in making sure that the rules packages do continue to move forward. There could be some small delays as they are trying to do that, but they are not, they have not indicated that we would need to put a halt on our rules packages.
Good. It's unfortunate to have even a little bit of a delay at this point, but my second question was triggered by comments from Ms. Copeland, the written comments, suggesting some, what I think at least initially might be helpful improvements to the legal aid attorney rules. And reading the work plan, it wasn't clear to me if those are coming back to us to revise more, or because it spoke in terms of the court having approved some changes. Anyway, are we going to see those in June?
Yes, so at the June meeting, we'll be presenting, kind of as if it's the first time, we'll be presenting to the committee a package for your consideration. The committee has previously looked at changes to the rules. They have been since revised since you last looked at them a couple of years ago. So this really, you should look at it as your first take on this new rule package. We will obviously be reviewing Ms. Copeland's suggestion in line with what will already be proposed by the working group. The expectation for the June meeting, to be clear, you are always permitted to take an action should you choose, but the expectation is that you will discuss the rule package, debate it, think about it, and then we will come back at the August meeting, at which point, having made any changes you suggest, then you would take an action to recommend to the Board of Trustees putting those rules out for public comment.
Okay, thank you.
Does anybody else have anything they'd like to pull off the consent calendar to discuss?
I'll make the motion to approve this consent calendar, Chair.
All right, seeing none, Gongora moves to approve. Is there a second?
I'll second.
Mr. Kramer seconds. Devin, please call the roll.
Bolton?
Yes.
Burns? Yes. Cow?
Yes. I think.
Gongora?
Yes.
Kaplan, not present. Kramer?
Yes.
Lawrence?
Yes.
Lee? Masiwala, not present. Montgomery?
Yes.
Reed, not present. Reyes?
Yes.
Reyna?
Yes.
Silva Guzman?
Yes.
Smith?
Yes.
Yokelson?
Yes.
With 13 ayes and 0 nays, the motion carries.
Next on the agenda is action on the inspection report and application for jointly accredited status, Cal Northern School of Law. This item is being presented by Office of Admissions Principal Program Analyst Natalie Leonard. Ms. Leonard, take it away.
Thank you, Mr. Chair.
So we'll have 3 items related to schools this morning, in addition to those that you saw on the consent calendar. How's the volume? Okay, great. The first one relates to Cal Northern School of Law. This school underwent a periodic inspection as an accredited law school and also applied for jointly accredited status. I'd like to thank Julianne Smith for participating on the inspection team. It is truly impactful to have members of this committee attend a portion of the meeting, and we welcome your feedback as to the process. The inspection report is attached for your review. The school presented in almost full compliance at the time of the inspection, and subsequent to the inspection, very quickly produced full compliance as to a few technical changes that they needed to make, which are detailed in the report related to disclosures. And as a general point of view, because we've seen an uptick in technical corrections to the disclosures, when we put forth the disclosure package this year, we will have additional support and additional checks proactively for all of the schools to prevent this type of issue in the future. With that said, Cal Northern demonstrated excellent compliance, excellent response, excellent documentation, and the recommendation is to approve the school for jointly accredited status. Dean Brooks, Sandra Brooks, is here today to answer any questions. I don't believe she plans to make a statement, but Devin, just to be sure, would you mind to recognize Dean Brooks?
I do not see the dean in attendance.
Okay, then we may proceed. She confirmed to me that she does not plan to make a statement.
So right now you're looking for a motion to approve. That's your recommendation?
Unless Julianne or Paul or Vince have additional comments.
The dean just raised their hand.
Okay. Dean
Does the
Brooks?
dean?
Oh, yes, I am here. I just wanted to make sure you guys knew I was here if you had any questions, but I want to appreciate and take the time to thank the folks that visited our campus. They did a great job with all of our constituents, and we appreciate the work that they've done. So if you have any questions, I'm here to answer. Thank you.
Thank you. Does anybody have any questions? Doesn't look like it. Any further comments from Vince or Julia?
I'll just say thank you for having me as part of the inspection. I thought Cal Northern was well organized. They appeared to take their work seriously. And the students we interviewed had all positive things to say about the school. So I would recommend voting yes.
Thank you, Julian. Vince, anything? Okay. With that, I'll entertain a motion to approve.
I'll move to approve.
I'll make the second, Chair.
Okay. Moved by Smith, seconded by Gongora. The motion is to approve staff recommendation. Devin, please call roll.
Bolton?
Yes.
Burns?
Yes.
Cow?
Yes.
Gongora?
Yes.
Kaplan, not present. Kramer?
Yes.
Lawrence?
Yes.
Lee?
Yes.
Masiwala, not present. Montgomery?
Yes.
Reed? Not present. Reyes?
Yes.
Reyna?
Yes.
Silva Guzman?
Yes.
Smith?
Yes.
Yokelson?
Yes.
With 13 ayes and 0 nays, the motion carries.
Okay. Thank you. Thank you, Dean Brooks. Next on the agenda is item 4.2, action on application for registration as an unaccredited law school, LA Law Institute. Again, the item is being presented by Natalie Leonard.
Thank you. So this school is a new application planning to open ideally later this year. July 1st is proposed. The committee considered the initial application of the school in October and asked that the school create a number of changes. The school was very responsive to those changes and did a significant amount of work to build out the curriculum that they will be offering, give a lot of detail that staff was able to review, and they are in the process of working on correcting and conforming their corporate documents, and that should be ready shortly. It may be ready already at this time. We're just waiting for the confirming documents here at the bar. Based on the significant progress versus what we saw in October, the staff recommendation is to approve the school with the following conditions. There are a number of compliance issues that are outstanding, but the number is much smaller than before, and they are largely technical. The school agrees to complete those within 1 month and to provide documentation of evidence to staff. It is recommended that those be completed. It is also recommended that the school be allowed to enroll 1 cohort at the start of the opening so that they can ramp up under monitoring, make sure everything that is in place as it should be. That they advise you whether or not they've started on schedule, though they're very eager to do so, and that they undergo an inspection in the 2nd trimester. So let's pause for a moment there. Why an inspection at that point? Presumed with the application process is a small inspection at the start. They have already set forth the funds, which are less than what would be expected for a full inspection. It's just making sure that everything opens in compliance and all of the students receive all of the benefits they need and can proceed toward their bar eligibility. My computer locked up, so I'm just going to unlock it with my notes while we're talking. And then also, once that inspection takes place, the committee can then better determine what sort of inspection calendar is appropriate for the school as it comes up to speed. This school intends to start with just first-year students only and then continue to build as it goes forward. A typical approval period for a brand new school is 2 years, and 2 years is recommended here. We may have Dean Brandy McAlexander visiting. And I don't expect that she plans to make a statement, but let's confirm, and she is welcome to do so.
They had their hand raised and they just lowered it.
Okay. Okay. If they've lowered their hand, let's proceed. And I thank Dean McAlexander for joining us today.
Thank you. Does anybody have any questions or comments? All right. Devin, can you put the resolution on the screen? Cody. Thank you. All right. The motion is to approve staff recommendation. Is there a motion?
I'll move the motion.
Vince Reyes moves. Is there a second? Kareem seconds. Further discussion? Seeing none. Devin, please call the roll.
Bolton?
Yes.
Burns?
Yes.
Cow?
Yes.
Gongora?
Yes.
Kaplan, not present. Kramer?
Yes.
Lawrence?
Yes.
Lee?
Yes.
Masiwala, not present. Montgomery?
Yes.
Reed, not present. Reyes?
Yes.
Reyna?
Yes.
Silva Guzman?
Yes.
Smith?
Yes.
Yokelson?
Yes.
With 13 ayes and 0 nays, the motion carries.
Thank you. Item 4.3, action on application for registration as an unaccredited law school, Pacific American University School of Law. Natalie?
Thank you. So Pacific American University, similarly situated, first presented its application to the committee in October. The committee asked for additional information, and additional information has been provided. The president of the program does have various experience in law, including an American SJD, but at that point they were proposing to use a skeleton of a similar program in place at another law school. In the ensuing 4 months, they've brought on an experienced dean who would begin work in May, if approved by the committee, an experienced registrar. Both of them are California licensees. They've operated programs before for both registered and accredited schools, and they similarly have built out the curriculum in a custom manner that fits the skills and the strategy of this school. They fully completed their compliance matrix, so they have no further compliance items. And otherwise, the recommendations here are very similar as for the prior school, to be able to grant permission to enroll 1 cohort to start when they begin opening, to confirm that they have opened as planned in fall 2026, which is the time that they have elected, to undergo an inspection during their second trimester, and at that time for the committee to determine what the appropriate further inspection and monitoring schedule is for this school. President Kang and Dean Weimer may be present. I will point out that she travels extensively. She may not be available as it would be 2 a.m. In her time zone.
I do see a raised hand.
Yes, this is Tim Weimer, Dean of Pacific American University School of Law. I had prepared a statement, but for sake of time, I think the recommendations by the bar staff are sufficient. And I just want to take a quick second to thank the bar staff over the last few months of helping us make sure we got everything in line like we needed to, so we're complying with the rules and guidelines. Thank you.
Thank you, Dean. Are there any questions from members of the committee?
I just had a comment.
Vince Reyes has a comment?
Yeah, I wanted to thank Natalie and Paul, part of the Education Standards Committee, because this school and the school previously that we just approved, because they're new schools, we really took a lot of time and to look at it in a very detailed fashion. And I think going forward, the inspection times, which are, I guess, sooner than later, come at a good time for these particular schools. And I believe at a reduced fee also.
Mm-hmm. Thank you, Vince.
Thank you, Vince. Thank you to Vince and Paul for your work on this. Anybody else? All right. Cody, could you share the resolution and the motion? The motion is to approve the recommendation of staff to allow the registration of Pacific American University Law School and for them to go forward. Is there a motion?
This is Vince.
Vince moves. Is there a second? I'm sorry. Alex Lawrence seconds. Devin, please call the roll.
Bolton?
Yes.
Burns?
Yes.
Cow?
Yes.
Gongora?
Yes.
Kaplan not present. Kramer?
Yes.
Lawrence?
Yes.
Lee?
No.
Masiwala not present. Montgomery?
Yes.
Reed not present. Reyes?
Yes.
Reyna?
Yes.
Silva Guzman?
Yes.
Smith?
Yes.
Yokelson?
Yes.
With 13 ayes and 0 nays, the motion carries.
Great. Dean, thank you for your presentation and good luck. Moving forward, item 4.4, discussion of report on access of issues at the bar exam test sites as required by Business and Profession Code Section 6060.10. Recommendation to the Board of Trustees for adoption and transmission to the Legislature. This item is being presented by Office of Admissions Principal Program Analyst Lisa Chavez. Lisa, please go forward.
Hello, good morning. My name is Lisa Chavez, and I'm here with my colleague Maria Rapier, and we are delighted to share with you a first report that's required now by statute to report out on, as the title says, access issues at bar exam test sites. Before we get into our presentation, I'd like to thank State Bar proctors and State Bar staff who, without their diligence in filling out incident reports and helping our applicants with test accommodations and responding to their requests, without them doing that diligent work, we really wouldn't have data on this issue of issues that arise at bar exam test sites that come from our testing accommodation applicants. And so you'll see in a moment the types of data sources that we draw upon, and they're all qualitative in nature. I'm a quantitative researcher at heart, but I was really delighted that we had such rich data to draw upon to fulfill the statutory requirement. So I'm going to share my screen and we're going to get started. And during this presentation, I'm going to be sharing this presentation with my colleague Maria Rapier, who is there. Can you see my screen? And I am so sorry I'm not with you in person today. I had full intentions of doing so. Okay. Maria, are you there? So let's get started. Okay, so let's first start with this new statutory requirement. This became effective on January 1st, 2025. And it says that commencing July 1st of this year and annually thereafter, the State Bar shall transmit to the Legislature a report that details the number of complaints regarding access issues related to our bar exam as follows: the testing location in which the complaints occurred, the nature of the access related complaints, the accommodations provided to the people who are levying these complaints, and any additional information the State Bar determines to be relevant and necessary for assessment of the existing programs for addressing access issues related to our bar exam. And this statute is going to be in effect until January 1st, 2030, and that date, the date is repealed. Okay, so now I'm going to turn this over to my colleague Maria, who's there in the room with you, and she's going to share with you about our data sources and our methodology.
Thank you, Lisa. Can you hear me okay? All right, great. So the methodology we used includes reporting complaints and requests by the accommodated applicants. The report presents all issues related, regardless of the accuracy or severity. If an issue is raised, it's included in the report. Analysis of the issues cover the July 2025 and February 2026 exam, and then additional analysis was included from the February 2025 exam to allow for more context. In alignment with the statutory reporting requirements, all analysis of the issues distinguish between issues that are related or unrelated to a granted testing accommodation. Issues related to a granted accommodation are treated as access related. Next slide. Okay, we identified these issues in 3 ways. There are additional item request forms. So all applicants who are granted testing accommodations are encouraged to visit their designated exam site the Monday prior to the exam. They can see their exam space, get familiar with parking, but they also might request items. Typically, they're minor, and there are things like replace a chair or cover a mirror or adjust the lighting. But all of these are referred to as issues. We also used instant reports. So Proctor and staff complete instant reports to document issues that occurred during the exam. These valuable reports capture instant details, how, when, why, and by whom the issue was resolved. There were also applicant communications. So applicants directly email through the applicant portal. They might email directly a staff member or this committee. They might send emails for public comment. Next slide, please. The report content, the analysis was across the exam cycle. So prior to the exam, we looked at the requests for testing accommodations, the outcome of those requests. We also, during the exam, of course, we looked at the types of accommodations granted, the number of the issues raised, the nature of the issues raised, the accommodations of the applicants who raised those issues related to their granted accommodation, of course, the exam sites where these issues were raised, and the outcomes of those issues raised. After the exam, we looked at satisfaction with the implementation of granted testing accommodations, and of course, look at bar exam pass rates as well. Thanks, Lisa.
Okay, thank you, Maria. So as you can see from this slide, we have this slide outlines all the analyses that are in the report, but in those analyses that are in bold, those are the ones that are required by statute. So this report contains analyses beyond those that are required by statute, but we include them because part of the statute says this, gives the State Bar, directs the State Bar to include any additional analysis they feel would be informed, that we feel would be inform this issue, and that's exactly what these additional analyses are about. So I'm going to go through some key findings next. Okay, so let's start with the analysis we did with regards to pre-exam. So what you see here is a slide on the outcomes of requests for testing accommodations. And so again, you see it across 3 exam cycles. And at the bottom, as you can see, what you should take away from this is that the majority of individuals who request accommodations, those requests are either approved or partially approved. The bottom line here, in gray, shows the number of applicants that have applied for testing accommodations. And it's always good to compare, like, February to February. So as you can see here, there has been an increase in number of applicants who are applying for testing accommodations. But overall, what you should get from this slide, that over 90% of applicants requesting accommodations received either full or partially approved. Now this takes us to the percent of test applicants who take the bar exam who had a testing accommodation. So now we are like at the exam, of all those who took the exam, what percent had a testing accommodation? And as you can see, the percent of applicants with a testing accommodation that completed the February exam increased from 10.8% to 12.7%. Yeah, that's a year-over-year change across the 2 February exams. If you look at the 3 exams that we analyzed, July 25 had the highest share of test takers with accommodations at 13.4%. Now this slide looks at the types of accommodations that were granted. And so here on the left is that we put types of accommodations in kind of big categories. And again, those categories are outlined in the report, but what you should take away from this is that across all 3 exam administrations, extended time or a modified schedule is the most granted testing accommodation. And in 1 year in particular, February 2026, all 100% of the 559 applicants that had a testing accommodation had extended time. The next biggest category are room-based accommodations. And this is where we give applicants a private room, a semi-private room, or a reduced distraction room. And then the third biggest category is the medical needs and rest accommodations. And finally, ergonomic and physical supports.
Lisa, a question
Yes.
for you. This is Paul.
Hi.
You're using the term completed, but I'm guessing you mean passed the exam. Is that correct?
Completed means that we use the word completed to mean that they completed the exam. Because we have some applicants that they attended the exam and then they did a partial exam. So when we say completed, those are the people who completed and their exam will be graded.
Then those percentages look really low.
Sorry, this is for every, I'm sorry.
Go back 1 slide.
Oh, the shit. Go ahead. So this is the percent of all applicants who took the exam that had a testing accommodation.
Gotcha. Okay.
Yes.
My error.
It's okay. Thank you. Okay. Okay. Now we're turning to issues raised during the exam. So we do the analyses at 2 different levels, at the individual level and at the issue level. And this slide here talks about individuals. That means our applicants. Okay, so the majority of the over 1,000 July 2025 applicants with testing accommodations did not raise any issues. That is that they didn't give us file a complaint, raise a complaint, or make a request. So only 7% did, and those are 72 applicants out of the over 1,038. Now, what this slide on this chart on the right does is take among those 72 applicants, tell us a little bit about what types of issues they raised and how many they raised. And what you should get out of this is that the majority raised 1 issue and it was unrelated to their testing accommodation or to their granted testing accommodation. So most raised just 1 issue. 7% raised two or more issues and all of them were unrelated. 19% raised 1 issue and it was related to their granted tested accommodation, et cetera. And the 6% at the top is that it had a combination of issues. They had 2 or more issues and some were related and some were unrelated. Okay, so now we're moving.
I'm sorry, Lisa, is there any theme to the issues that were raised that were unrelated to the granted accommodations?
Yeah, we'll get to that next.
Okay.
Okay, thanks. Okay, so now this is about individuals, and now we're shifting the unit analysis to issues. Okay. Okay. So when you think about those 72 applicants that raised at least 1 issue, I just told you that some had 1 or more than 1. So on the whole, that resulted in 86 issues across the 72 applicants. The majority had 1, but some had 2 or more. So as a result, we had 86 issues to analyze, and that's what this slide is going deep on. So here on the left says, okay, out of this 86 issues raised by the 72 applicants, 66 were unrelated to a granted testing accommodation, and 20 were related to a granted testing accommodation. The chart on the right says, tell me about what's going on with those 20 issues. And here on the right, this has to do with what were the granted testing accommodations related to those 20 issues. So here's the 20. The biggest category was room-based accommodation. So of 8 issues were related to an issue that the granted accommodation of those 8 issues was a room-based accommodation. The next one had to do with extended time or modified schedule. The next category was exam format or materials. And then the last was ergonomic and physical supports. So again, this is doing right here, this is describing the granted accommodation of the individuals who raised these issues. And that means that the issue that they raised was related to that. So what we talk about in the report here is for the room-based accommodations, most of the issues raised had to do with noise. People complaining about the level of noise in the rooms made by proctors, made by other applicants, made by people outside their rooms. And so we counted that as related to their granted testing accommodation. And the next biggest category is extended time schedule. And the majority of those issues raised were people concerned that they were not granted all of their time.
Lisa,
okay. So now this slide, this has to do with the types of issues raised. So this gets to tell us about if they were asked an issue, raised, well, what did that issue have to do with? So here on the left.
Lisa, one second. I'm sorry, I didn't have the mic on before. You couldn't hear me. Okay. So I just wanted to back up a little, just very briefly. When Lisa was talking about the noise and distractions as related to testing accommodations, there were several inflection points that we had as we were putting together this report. For example, do we just include complaints? Or do we also include these requests that people made for, can I have an additional light? Can I change out this chair? I prefer one with a higher back. I prefer one with a lower back. I prefer one on wheels or not on wheels. And at each of these inflection points, what we tried to do was err on the side of counting these things and reporting on them, because we didn't want to be guilty of mischaracterizing something and say we're only reporting on complaints, not these requests, and then have somebody say, well, that wasn't a request, that was a complaint. Similarly here with the noise and the distractions, just because somebody was granted an accommodation for a private room or a semi-private room or a reduced distraction room, it wasn't necessarily because their disability required them to have quiet or required them, right? They may have had the need to, they had a back issue and they needed to lay down on the bed in the hotel room in between or during the session. So we would have granted them a private room. Regardless, if somebody in one of those room types, private room, reduced distraction, or semi-private, made a complaint about noise, the person next to me is too loud, the person in the room next to me is too loud, the proctor's too loud, we counted those as related to the accommodation, again, in the interest of erring on the side of over-counting as opposed to under-counting. And I just wanted to make that point very clear here. Sorry, Lisa, go ahead.
Thank you so much for that. Okay. So here on the left, this describes the types of issues that people raised. So it's disaggregated by the 20 issues that related to the granted testing accommodation and the 66 issues that were not related. So let's start here with this table on the left. So noise and distractions comprise the largest category of issues that were related to a granted testing accommodation. So that's what you should get out of here. Whereas among the 66 issues that were unrelated to a granted testing accommodation, 36% of them had to do with the testing room environment. Okay, here on the right, this has to do with outcomes of issues raised. That is, what was the State Bar's response to these various complaints and requests that we received? And as you can see, regardless if it was related or unrelated, 80%, we were able to provide a prompt adjustment or a fix to the complaint or request. And then finally, we analyzed data on exam sites for issues raised. And again, this is part of the statute requirement. And so here, among the 20 issues that were related to a granted testing accommodation, the majority were raised at 3 sites, the State Bar's Los Angeles office, a hotel in Anaheim, and the Oakland Convention Center. But in contrast, these 66 issues that were unrelated, they were a little bit more broadly distributed across the exam sites. And the reason why we have these standard sites down here is because, in point of fact, some of our applicants with testing accommodations are assigned to what we call standard sites if their accommodation can be fulfilled at these standard sites. But none of those few people who were assigned there raised a complaint or an issue at one of the standard sites. Okay, so the rest of the slides have the exact analysis for February, and I'm just going to go ahead and skip through because it essentially tells the same story. Okay, and so in the interest of time, I'll just go ahead and skip through get to the post-exam analyses. So we analyzed bar exam pass rates, and so far we have data for February 25 and July 2025. We will update the report after May 1st when February 2026 results are released. But so far, what the results are showing that across these both exam administrations, applicants with testing accommodations have higher bar exam pass rates than those without accommodations. And this pattern is consistent for first-time and repeat applicants, although the pass rate gap was smallest among the repeat applicants in July 2025. And then finally, we leveraged our post-exam survey, and we, starting in July 2025, we included questions about how I'm sorry?
No, go ahead.
Okay, great, thanks. So what this, the survey item was, one of the survey item was thinking about and this was asked if you had a testing accommodation, then they received a series of questions on our post-exam survey that we give out every post-exam. And the question was, thinking about the accommodations you were approved for, describe your level of satisfaction with how those accommodations were implemented during the exam. And so we have data on two exams for now. And what it shows here is that the majority of applicants with testing accommodations report being satisfied with the implementation of their granted testing accommodations. Those are these 2 bars here combined. But however, something we noticed was that the distribution shifted modestly between these 2 exams, where there's a smaller share that are very satisfied. It went from 48% down to 44, and there's a larger share reporting being somewhat dissatisfied. It went from 9% to 16%. Okay, so our conclusion then in this report is that at a very high level, we've concluded that most applicants with testing accommodations did not raise any issues during the July 25 and February 2026 exams. Among those that did, the majority raised just 1. Most issues raised were unrelated to their granted testing accommodations. However, among all issues that were related to a granting tested accommodation, the largest share were associated with room-based accommodations. And in July 25, most issues related to a granted testing accommodation occurred at 3 sites, whereas in February, those issues were more broadly distributed. So staff recommends that the committee approve the legislative report and recommend that the Board of Trustees adopt the final report and direct staff to transmit it to the legislature in accordance with statutory requirements. Thank you very much. I can answer any questions you have about the report.
Thank you, Lisa. That's very thorough and very informative. Do members of the committee have questions or comments? Julianne.
I thought the report was really well done. I just have a few clarifying questions. For the post-exam survey, is that sent to all applicants who completed the exam or anyone who signed up for it? And then this might be more for item 4.7, so I can save it for that if needed. But are we concerned about the source of data if we go with the NCBE, if there are complaints made by test takers to NCBE? Are they going to share those complaints with us? I was thinking maybe if there's a complaint on the test format or materials, are we going to see those?
Or on accommodations?
Correct. Are we going to see those complaints that were made directly to the NCBE?
Should we save that for 4.7? Okay, we're going to save that one for 4.7. But what about the first question?
Sure. Sure. So after every bar exam, we administer a survey to everyone who took the exam. So so the time that the survey goes out, we still don't know who was only a partial completer at that point. So to answer your question, it's everyone who was scheduled to attend the exam and actually attended, even if they hadn't completed or were partial. So we picked up a few extra people who didn't necessarily complete it by our own.
Hi, thank you.
Yes.
Thank you. Random comments. Did I see a different hand? Thought I saw somebody else. Michael. Microphone.
Okay, great. Just a small comment. This is so impressive, and I really hope to see more of this to help guide us in other areas, because I think, while it's not the discussion for now, using this data, I think we can start to analyze where to make the accommodations and where the problem is. And this is something that we had, I think, in the core of what we're trying to decide of directing the exam. This sort of data would help us go forward rather than making a lot of assumptions. This has been just phenomenally impressive, and really appreciate the work.
Thank you for your words.
Any other comments or questions? Seeing none, can we put the resolution back up? Okay. Is there a motion to approve the report? Kareem Gangora moves. Is there a second?
I'll second.
I'm sorry, Julianne. Julianne seconds. Devin, please call the roll.
Bolton,
Yes.
Burns,
Yes.
Cow,
Yes.
Gongora,
Yes.
Kaplan not present, Kramer,
Yes.
Lawrence,
Yes.
Lee,
Yep.
Masiwala not present, Montgomery,
Yes. Yes.
Reed not present, Reyes,
Yes.
Reyna,
Yes.
Silva Guzman,
Yes.
Smith,
Yes.
Yokelson.
Yes.
With 13 ayes and 0 nays, the motion carries.
Thank you. Item 4.5, we're scheduled for a break in about 10 minutes. I thought we'd power through this unless anybody wants to take a break now. All right, let's do item 4.5 and then we'll take our break. So next on the agenda is discussion and action, if appropriate, on the February 2026 past bar exam survey results. This item is being presented by Office of Admissions Principal Program Director Analyst Lisa Chavez. Lisa, again, your floor.
Okay. So as I mentioned in my previous presentation, after every bar exam, we administer a post-exam survey. We do this survey for lots of reasons. First and foremost is to learn about our applicant satisfaction with the exam. And over the years, this survey has really undergone some serious development and expansion. We ask more detailed questions about technical issues experienced. We added questions about testing accommodations, the testing accommodation application process, as well as experience during the exam. And so I'm pleased today to share with you the results from the February exam. In response to some previous examiner who once asked to learn more about how applicants were experiencing state bar service in terms of information we're giving applicants as they preparing for the exam, what we did was we pulled together some trend slides because we had never really gone deep into those results before. So when I share with you a presentation, I know we gave you this really comprehensive deck, but I'm going to just share with you a few slides that we would like you to focus on for this presentation. Okay, so let's get started. Okay. I'd like to thank my colleagues in the Office of Research and Statistics because they help us refine the survey and they also administer the survey for us. Okay, so, again, this is the February bar exam that just took place. Our response rate was around 20%. And just as FYI, the trend data that I talked about, we don't include trend data for February 2025 only because that exam had very well documented technical issues that affected most applicants. So when you see trend data on technical issues and exam satisfaction, we skip over February 2025 and we go back to February 2024. Okay. Okay, so let's start first with satisfaction with the State Bar pre-exam communication and other services that we provide. So what we learned is that most applicants, when they're asked, what sources of information do you review to learn about exam day policies and procedures? The top sources of information that our applicants are using is our email communications, and this is across 3 different exam cycles going back to July 2024. The State Bar exams website, and then the admissions ticket bulletin. So that was good information for us once we looked it over at this time to say that they're consistently making use of these 3 sources of information. Less so, their law schools and ExamSoft's website and the NCB website. But what we thought that was interesting was that the review of our own website kind of peaked at 86% in July 2025, and it fell to 69% in February 2026. In July 2025, the question on the survey presented all these different sources of information and asked if you agreed if the information was timely, if it was communicated clearly, and if the information was thorough and sufficiently addressed their concerns. So what these bars represent are the percent of applicants that, among those who said that they reviewed that item, the percent that agreed with that statement. So what we see here is that 81 to 87% of applicants in July 25 thought that the information was provided in a timely manner. So this was the range here. With regards to the clarity of the information, those ratings were lower. They were down between 69% and 74%, with the State Bar's website receiving the lowest rating so only 69% felt that our website, the information was communicated clearly. And with regards to thoroughness, those ratings were really the lowest, ranging from 61 to 64% across all resources. So we see some areas of opportunity here, especially with regards to our website, and you'll see that more clearly in the next slide as well. So here are the next few slides. So in February 2026, we updated the survey items to change it from whether or not you just agreed with it, yes or no, to more of a Likert scale. So what this says is, so for each of these items, it's to what extent do you agree that this information was provided in a timely manner? And over 60% of applicants strongly agreed that the email communications, the admittance ticket, and ExamSoft's communications were provided in a timely manner. That's the percent that strongly agreed. Whether or not the information was communicated with clarity, over 60% strongly agree that the email communications, the admittance ticket were communicated clearly. But something to note here is that less than half of our applicants, only 48%, strongly agreed that the information on the State Bar's website was communicated clearly, and 13% reported some level of disagreement. So again, that we see this as an opportunity for us to improve our website. And similarly here, it has to do with it. To what extent do you think the information was thorough and sufficiently addressed your concerns? Again, I'm just going to go straight to their website finding again, less than half strongly agreed that the information was thorough, and 12% reported some level of disagreement. Okay, so now we're going to talk about the questions that we added, and we're so delighted that we did so. We have two exam administrations, and it has to analyze, and it has to do with to what extent people were satisfied with the process that they underwent when applying for testing accommodations. And the way we analyzed this data was we categorized people according to the administrative data on whether all their accommodations were approved, whether they were partially approved, or whether they were denied. And then we, based on those 3 category applicants, we analyzed this survey item. And ultimately, people whose requests for accommodations were approved were generally more satisfied with the application process than applicants whose requests were partially approved. And in general, applicants who were denied their testing accommodations that they requested were very dissatisfied with the testing accommodation application process. Okay, now I'm going to turn to the exam experience. So in the wake of the February 2025 exam, we're really paying attention to this question to the extent to which our applicants experience a technology issue. As we know, majority of applicants in February 2025 experience a technology issue, but we've been asking about technology issues since before that exam. So what you see here is starting in July 2024, around 15% experience a technology issue. And it's been kind of steady since then, again, subtracting out February 2025. And as of like February 2026, only 12% experience a technology issue. And what does that mean? That means that if anyone selected one of these items, they were counted as if they experienced a technology issue. So it's like a select all that apply. And so of the 12%, so think about it as the 12% who indicated they experienced a technology issue, this is the percent that reported which issue it was. So what you should get out of this is that the biggest issue that they're reporting is that the copy and paste functionality did not consistently work. That's the biggest issue. Here on the right, what this chart shows is that using the total survey respondents as the denominator, what you see is that only 4% of test takers reported that copy and paste functionality did not consistently work. So it's really important that we analyze the data this way, because one could say, 38% of our applicants didn't experience a copy and paste issue? No, it's really 4% of all applicants who filled out the survey reported this. It's 38% of applicants who had at least one issue who are saying that the copy and paste function didn't work. So now we turn to, okay, this is actually, I'll skip through this. This is the same slide that I presented as part of my previous agenda item. It has to do with satisfaction with accommodations. Okay, so now this is overall satisfaction with this exam. And this is a question that we've been asking very consistently over the years. So what we find is that the majority of applicants remain satisfied with their exam experience. Those are the two blue bars. However, and overall satisfaction has increased slightly from 55% in July 2024 to 59% in February 2026. And again, that's combining the two bars together. So going from here to here, we see an increase in satisfaction. Finally, we've asked questions about exam modality preferences. And again, we've been asking this for a while now. And so what we've discovered is, okay, so at the top, these are the exams for February. So we have 3 years of exams for February. And at the bottom, this is for July. And so what we see is that the preference for remote testing has declined substantially from 64% in February 2024 to 34% in February 2026. And the reason why we just put it out this way is because, as you can see, we've been kind of changing the question over the years. And that's why, see, when you see the blue bars, that's the blue bar that's kind of that's measuring remote for that particular exam question. And so now a majority of applicants now prefer in-person testing. And this shift really began in 2025. Okay. So now I'm going to turn to a set of survey items that address certain demographic and situational factors. And so in October 2024, the Supreme Court issued the following directive: that the court further supports and encourages the use of intervention programs such as the California Board Exam Strategies program to potentially ameliorate disparities. In addition, the State Bar is encouraged to survey applicants and assess any demographic and situational factors such as psychological stress and financial hardship that may be addressed by such programs. So in response to this directive, we added new questions to the February 2026 post-exam survey that will address situational factors that applicants have faced that are known to really impact bar exam performance. So these include items related to exam preparation, resources used, the hours worked while people were studying, and how the applicants financed their legal education. So our plan is to serve as to refine these survey items over time, expand them over time, and then do some series of analyses going forward on like how there's variation by demographic factors in these survey items. But for now, what I'm going to do is I'm just going to share with you just a few key findings. So let's talk about exam preparation support. So our applicants were asked, well, studying for the exam, did you have access to any of the types of social support? And as you can see, is we're talking about like disparities and people's factors that can impact people's performance. I'm going to go ahead and focus on the 16% that they did not have access to any of these forms of social support. So while it's good that 70% said that they had emotional support, 33% said they had workplace support, you know, 16% of our applicants said that they had access to none of these forms of social support. Here on the right, this is just the percent of our applicants that have participated in our intervention programs. And here on the bottom, it shows that over 2/3 of applicants used a commercial bar exam prep program or a course or a program. Next, we turn to whether or not people purchase exam materials. And we found that even though the majority said they did, 8% said no. Here on the right asks, for those of you who said that they didn't purchase this, why not? And over 2/3 of the applicants said that they didn't purchase it because ultimately the costs were too high. And then the 39% said that they were able to access free materials. And down here on the left, 40% of applicants report it was, quote, very challenging, unquote, to cover costs related to exam prep. Next, we asked a series of questions on to what extent people were working when they were preparing for the exam. And what we found was that over 1/4 of applicants did not reduce their work hours or stop working to focus on studying the exam. Over 1/3 of applicants were actually working full-time while studying for the exam. The majority of applicants found it somewhat or very challenging to cover their costs related to living expenses while studying for the exam. And 1 in 5 applicants reported that financial concern had an extreme impact on their ability to concentrate on studying for the exam. So again, as I started this section, our plan is to take all these findings and now explore how there's variation by race, ethnicity, by gender identity, by first generation college status, et cetera, to really see to what extent these findings vary by different groups. Okay, that is all I have. And I can answer any questions that you may have about the survey or any of the findings we've highlighted today. Thank you.
Again, very complete. Thank you, Lisa. Are there questions or comments from the committee? Alex.
Sorry, but not to go too far back. There was an explanation in the reduction of interest in taking the exam remotely. Can you just go over that part again, explain why? If there's any insights as to why that did occur over here.
Were you able to hear that? Lisa, were you able to hear that? No.
No.
All right. Let's try it again.
I'll try it again. So you shared that there was a reduction in interest in taking the exam remotely year over year. Do you mind just explaining perhaps reasons why or any insights again?
Lisa, could you hear?
I did hear that. I could ask my colleague Donna Hershkowitz to help me out with this one. I mean, it started in July. This trend started in 2025. We know what happened in 2025. I think we're all kind of assuming that the February 2025 exam impacted people's perceptions of the remote exam experience. I think that's the only thing we can think of that happened, because it is a real trend that started in 2025.
Okay, thank you.
Thanks.
Thanks, Lisa. Any other comments or questions?
Just one quick
Yeah,
question.
Julianne. Mike?
Can you hear me? All right. Are the technology issues reported shared with ExamSoft as far as making sure that there's prevention of those technology issues in the future?
So yeah, so that is absolutely our plan, to share it with ExamSoft, to understand their answers, and obviously that would be as we are evaluating software platforms going forward, right? Understanding what the issues what issues there may be and whether those are resolvable issues, right? We also had questions, which Lisa didn't go through, about sort of satisfaction with customer service, right? Customer support, if there were reports of technology issues and things along that nature. So that's the great thing about this data, is it does give us something to follow up on and see, what is it you can tell us about this? So that's absolutely in our immediate plans.
Kareem?
Yes, thank you, Chair, and thank you for the presentation. For the partially approved applicants, was there any analysis of which specific accommodations were denied and how that correlated with satisfaction levels?
No, we haven't done that analysis.
The only reason why I asked is because obviously in our role, we partially approve some of these accommodations, and so just trying to get a deeper understanding.
Trying to see how we're doing.
More or less, Chair.
Yeah.
But thank you, Lisa. Everything else is very thorough, and I really appreciate this whole presentation.
Thank you. Anybody else? Seeing none, is there, I think there's a resolution. There is no, what are we doing? Just, this is for information only?
Information, unless you want to adopt a resolution.
Keep up the good work. All right. It is now 10:38. Let's take a 15-minute break. We'll come back and take up the next item. So, yeah, about 10:55. We'll be back. Thank you, everybody. No roll call. All right, welcome back, everybody. Thank you for that quick break. I remind everybody that this meeting is being recorded. Next on the agenda is item 4.6, discussion and action, if appropriate, to seek revisions to the Business and Profession Code section 6060 and State Bar Rules 4.26 and 4.55 regarding eligibility to sit for the bar exam or be certified to the Supreme Court for admission under the, quote, studied diligently and in good faith, unquote, standard for an eligibility to sit for the first year student's exam. This item is being presented by Office of Admissions Director, Programs Director Tara Clark, and Office of Admissions Programs Manager Christina Dole. And I don't see Tara there.
I'm here.
Oh, there you are. I was looking at the table.
And
I said, David, you're not Tara. Okay.
can you hear me on the microphone?
If you speak up, just.
Oh, goodness. Is that better? Okay, I'll try. Let me know if I get too quiet. So thank you. So this item is being brought to you today. Mr. Kramer, I think in December, had asked that we look at the provision that allows applicants to study law diligently and good faith for 4 years and still qualify to sit for the bar exam. And so I won't go into as much detail as the staff report, but so what that means is someone can have taken some number of years of school in a law school and then potentially not complete and get their JD. Also, they could potentially have done some work through the Law Office Study Program, but again, not complete the full 4 years through the program, but still qualify to sit as long as they have enough credits and meet that 4-year status. And so should the committee be so inclined, this would require a statutory change. So it would be a recommendation to the board to add this as a legislative priority. Today it's on the agenda just for an initial discussion, and we plan to bring it back in June. If you'd like, you do have the option to move it forward now, but I know during the break we spoke with Mr. Kramer for a moment, so I think he has some suggestions. So the plan, as far as I'm aware, is to bring it back in June again. And so Business and Professions Code Section 6060E and State Bar Rule 4.26 would both need to be amended if we were to change the ability for applicants to sit after studying diligently in good faith for 4 years. And so if you look at the tables in the staff report, about 5% of applicants qualify to sit for the exam under this rule. But of those, 90% have report that they obtained a JD from one of our registered unaccredited schools. And so in discussions with staff, we believe that this is a holdover from when the state bar did not oversee the unaccredited schools, which is why we were looking for the 4 years of studying diligently in good faith. However, since the state bar has overseen these schools since 2008, we think it's appropriate that we instead recognize the JD from these schools as allowing them to sit for the bar exam rather than looking at the credits. And so then the second part of that is whether or not there should be a provision to allow someone to do any sort of combination. And so right now, the rule says that they can sit by any combination of these methods. Again, we think that's tied to the fact that the state bar did not previously oversee the registered schools, so it was more of a method for them to transfer between the ABA or Cal accredited schools and the registered schools, whereas now that's not how it's being utilized. There are some applicants who, again, just take 4 years of courses at any schools. They don't ever complete a program, but yet they're eligible to sit for the exam. So the two options, should the committee decide to eliminate that, would be to either completely strike the provision, and so it would mean that applicants either have to complete a JD from one of the three school types or complete the law office study program. And the alternate that we had spoken prior to the meeting with Mr. Kramer about was allowing them to potentially start at a law school, and then if for some reason, maybe it's financial concerns or otherwise, they'd be able to transfer to the, let's say transfer, they would be able to go to the law office study program and complete their studies there. The inverse, however, would not be true because the schools don't have the ability to successfully evaluate what was done in the law office study program and put that into the JD program. So it would be a one-way pathway from the schools to the law office study program. Also, part of our recommendations here are to define studied law diligently in good faith, which would include that they have a sufficient GPA for that school, they remain in good standing, they met the eligibility requirements to continue into the next year of study, and they were not academically dismissed from their school. And I do have both the red line version and the Word doc up if we'd like to look at those at any point, or I can keep going on to our second part of this.
Are there any questions so far?
Oh, one, in addition to the feedback I gave you, which I don't think I need to. Well, I thought it is on. Is that better? In addition to the changes, that I was just trying to, I gave them some changes to unify the statute changes and the rules. They weren't changing the content at all. I wonder though, do we know if somebody would be caught by the prohibition from going from law office study to a law school? Do we need some kind of like transition rule that if you're in that boat now, you can finish your program? Do we know that?
And Natalie, please correct me if I'm wrong, but I believe as it stands that the law schools cannot accept law office study credit as transfer credit, so it's not something that currently exists.
Okay, good.
And so the second part of the recommendation, so Business and Professions Code Section 6060H and State Bar Rule 4.55, these both deal with the first year law students exam. It's related in that we have applicants right now who are exempt from the first year law students exam, applicants who have met the undergraduate requirements and then they attend an ABA or Cal accredited school for their first year of study and successfully complete it are exempt. However, we do have applicants who do not successfully complete their first year at these schools. Hypothetically, someone gets all Ds, so they would be academically dismissed. They would then have to take the first year law students exam because they no longer have an exemption. If they were then to pass the first year law students exam, it creates an issue because the law schools are then accepting credit for a year that the applicant was not really successful at. They got all Ds, they were academically dismissed from their school. And so the proposed changes would make that person ineligible to sit for the exam. So the remedy then would be to retake that first year, either be it at their school or at a different school.
I'm sorry, which exam?
The first year law students exam.
Be ineligible.
Correct, yeah. So instead of the current situation where they would have to sit for it and then get this year of transfer, this year of study, but then that really shouldn't be accepted by any other school, it would just require them to redo that first year.
I see.
And are there any questions on that? And maybe what I could do is let me put up the changes we talked about with Mr. Kramer.
While you're doing that, let me ask council, realistically, we need to go to the legislature for some of this.
Yes, correct.
And realistically, there's no timeline on that, correct?
Donna can better speak to that, actually.
That's true. Donna.
This is the one time when it makes sense that I have the dual role of chief of admissions and legislative director. So the process would be this: if the committee asks the board to advance this as a legislative priority, decides that you want to do this, we would then take it to the Board of Trustees, and depending on where we are in the legislative cycle, we could either see if the legislature would be amenable to including this into this year's state bar fee bill, which is AB 2784. But if this is going to come back in June, then it wouldn't go to the board until July. There's a decent chance that it wouldn't be included in the fee bill until next year. But it's just a timing question. But we would do that, and then we could follow that with rule changes, and we can sort of do the rule changes concurrently, such that we would be moving the rules forward and putting them out for public comment, with the idea that if the legislature adopts the changes that are proposed, then the rules would become effective. So we don't have to wait for the statutory changes to be enacted before we begin the rule process. So that can sort of help move the process forward a little bit.
The rule changes would be required Supreme Court approval, correct?
Yes.
Okay.
And then just a note as well,
Yeah.
if we are able to move forward with the statutory changes, it would also mirror some of the changes I believe that the Ed Standards Unit is looking at making with the law school rules as well. So,
Well, given all of that, it's not that long to wait till June, but we could get a head start today moving this forward. Is there any reason not, assuming the committee, we have a consensus on this, is there any reason to wait till June to take action on this?
I think if we can address Mr. Kramer, and if there are any other committee members have any changes they'd like us to make today, then we can adjust the resolution just to say today is amended and then move forward with that.
Are there any comments about taking action today, or do we want to wait till June? Paul?
Well, one of the changes I talked to them about, we don't really have the language for yet. And that was about how to deal with making sure, that's probably a rare case, but somebody could, for our standard of diligent study, currently it just says if they have a grade point average for the time they're trying to get credit for that meets the school standards, then we would say they were diligent. But I came up with at least a hypothetical case where somebody may have, I think David said it's possible if somebody has all A's and an F in one course, which I think we would all agree you shouldn't get credit for that time spent. Their grade point average might meet the school standards, but I don't think we want to give them credit for that particular instance. So that has yet to be written.
I wonder if just so the committee is aware, it's on the screen, the highlighted portion that we're talking about right now. If we were to add in successfully completed, Paul, do you think that addresses it? Because if they got an F, they wouldn't have successfully completed the course.
The only problem, I guess, would be that if the school Although the diligence is just in our regs, right?
It's in the statute as well.
It's also in the statutory?
Mhm.
But we define what diligence means only in our rules.
Yes.
So if it's the case, then the statute could go forward.
Yeah.
Because we're doing the work administratively of defining it.
Mhm.
So, yeah, so we could leave that one little instance identified for later, and we could peel off certainly the statutory change, get that going today, and then bring the other one back maybe next time.
Yep.
Okay,
That works.
all right. Are there any other thoughts or questions? So how would we do that? Do we need to modify or have a separate motion to peel off the legislative component?
Well, I think if we can look at the statute just really quickly, I think this was one internal inconsistency Mr. Kramer had pointed out. We just wanted to strike the highlighted wording just to make sure that the applicants would receive, if they pass the first year law students exam within the first 3 administrations, they would get credit for all studies successfully completed until the time they get their results, not just when they take the exam. And so just to ensure consistency between the statute and the rule, we were going to strike this. So if there's no objections, we can do that, and then we can look at the motion. And
Okay. Are there any objections to that? Seeing none, go ahead. Strike it.
bring up the motion documents.
Jury is instructed to disregard, not consider.
So maybe this is a question for.
I'd take out the middle result.
Just that's what I was going to ask. Just remove it completely. Okay.
So what we're proposing is taking out the resolution that deals with the rules right now, changing the final resolution to reference, you already did that, A through B instead of A through D. And then we'll bring back the rule language in June, at the next meeting, and talk through that. And then we can adopt a resolution that says at the appropriate time, as the statutory language is moving forward, that we would advance the rule language.
Yeah, I just see that in the second paragraph there, it says proposed statute and rule revisions, but rule revisions were just taken out, so.
In the bottom one, Tara?
Oh, yes. Thank you. There we go.
I'd make that motion if we're ready for that.
Okay. Any other comments?
So you got revisions also?
Okay. Mr. Kramer moves. Are there any seconds? Seconds? Okay. Michael Lee seconds. Devin, please call the roll.
Bolton,
Yes.
Burns,
Yes.
Cow,
Yes.
Gongora,
Yes.
Kaplan, not present, Kramer,
Yes.
Lawrence,
Yes.
Lee, Masiwala, not present, Montgomery,
Yes.
Reed, not present, Reyes,
Yes.
Reyna,
Yes.
Silva Guzman,
Yes.
Smith,
Yes.
Jokelson.
Yes.
With 13 ayes and 0 nays, the motion carries.
Great. Good work. Thank you. Thank you, Tara. Okay. All right. So the good news is we are way ahead of schedule right now. So I'm going to take an item that was scheduled for after the noon hour. Item 4.9, discussion and action if appropriate on the CSBARS. Huh? What? I hear comments?
I think Cody will start something.
Yes, sorry about that.
I'm sorry. Cody, would you be ready to take up 4.9?
I am, yes. I was eager and jumped the gun on the unmute.
Yeah, I
Okay.
should ask you before I sprung that on you. So next on the agenda is discussion and action, if appropriate, on CSBAR's feedback regarding opportunities to collect enrolled student demographic data. The item is being presented by Office of Admissions Program Director Cody Unanian. Cody.
Great. Let me just get my slide here. So this is a discussion that's related to an item on the 2026 work plan, which is to explore opportunities to collect additional law student demographic data through our law school compliance reporting. The goal, at least initially, is to provide more nuanced insights from the data that we collect, similar to some approaches that have been used with some other state bar reports, such as our attorney census, and I'll talk about those more in a moment. The purpose of today's discussion is to provide an update to the committee following an initial discussion with CSBARS about this topic, and to seek from the CBE guidance on how to prioritize this work moving forward. Really, staff is interested to better understand, in light of the feedback that we received, whether we should continue exploring this initiative or whether we should defer it in light of some of the concerns that were raised in our CSBARS meeting. And I'll summarize those in a moment. Before I get to that, let me just kind of set the stage here. Currently, the State Bar collects student demographic data primarily through two methods. First, we at the State Bar collect directly demographic data from law students who register with us through the applicant portal. That data set is useful. However, it has some important gaps that I want to identify. Students who apply but do not enroll in law school are not covered by this data collection effort. Students who enroll but never actually register at the State Bar, often perhaps because they ultimately attrite from their program, they're also not covered. And then there's just a time lag situation where there are students who are enrolled but register with the State Bar later than anticipated. And so we capture that data kind of later in their journey. Second, we collect a number of important demographic identifiers and data through our law school compliance reports. So law schools are required to collect student demographic data and then report it to the State Bar through our annual compliance reports. In some ways, this is more complete. It includes all applicants who have applied, all applicants who are enrolled, and that's regardless of whether or not they've registered with the State Bar. So this second piece of data, the law school compliance data reporting, is really important for our oversight work. We use it to assess a number of our accredited law school rule requirements, particularly around access and diversity. And we also use it as the primary data set for our law school performance report, which we release annually in summer. We recently, well, I wouldn't say recently, we most recently updated our demographic questions and response options with a rollout of this new regime between 2020 and 2022. And the goal of that effort was to take the questions and the response options that we require schools to use when collecting demographic data and to align that with similar efforts by the ABA and perhaps more importantly, similar efforts that are required by the U.S. Department of Education through their IPED system. And that second piece is important because some of our schools are schools that receive federal student aid funding, and to be eligible for that, they have reporting requirements to the Department of Education. Alignment at that time was determined to be really important to the law schools because it means that they only have a single kind of data collection and reporting requirement as opposed to creating kind of two separate distinct burdens, reporting burdens. So today, the State Bar, the ABA, and the IPEDS requirements all currently require collection of race and ethnicity data and gender data. The State Bar's law school demographic, student demographic data also includes sexual orientation, disability status, and veteran status. And then more recently, IPEDS has introduced several socioeconomic identifiers, not required of all institutions, but I'm just sharing them here because we're going to discuss later in the presentation how some of our stakeholders have proposed using some of these socioeconomic identifiers as a way to provide some color about the unique population of students, particularly at our California accredited and unaccredited law schools that typically have non-traditional students. So at the onset of considering whether or not our law school student demographic data should be expanded, added to, enhanced, we were really looking at other efforts at the state bar that are doing similar things. And one of them is the attorney's census. And so I wanted to just provide this as a visual example, just so that members have a kind of a sense of the direction that we are talking about taking this data in the future. So this is just an example, but for the attorney census, we expanded the response options for race and ethnicity, gender and sexual identity. So you can see on the right-hand side here, we are now able to report on more nuanced subgroups within our race and ethnicity data. So for example, what's shown here are subgroups for Asian and Latino different demographic identities under those groups. Similarly, there was an addition of questions regarding veteran status, gender and sexual identity, adding this kind of additional nuance to the high-level questions that had existed prior. So when thinking about whether or not to add demographic data and questions and response options in law school reporting, staff really believe that there could be a benefit to considering kind of similar updates to what we saw with the attorney census for a number of reasons. One benefit is that it provides kind of a more nuanced look at the demographics, again, those subgroups that I just showed on the screen. There's also, I think, a belief that having additional response options, and particularly those subgroups, may better reflect the actual personal identities of students. And really, as far as kind of an analysis, a reporting, and perhaps a kind of data-informed policymaking process in the future, we saw these opportunities that that aligning the law school reporting with some of these changes that are happening, let's say with the attorney census or elsewhere at the state bar, could really open the door for some interesting comparative analysis that could kind of draw a through line between our student population, our test taker population, and then all the way through our attorney population. Having that extra nuance also opens the opportunity in the future to kind of better target access and inclusion efforts by understanding these communities kind of with more specificity. But in thinking about kind of expanding the demographic data collection and reporting, there are some substantial challenges, and I want to identify a few here, and then I want to share some that were identified by CSBARS. Moving away from our alignment with the ABA reporting requirements would actually complicate perhaps some of our comparative analysis across law school categories. And that was something that was very important when we published a different report, the Profile of California Law Schools, I think about 2 years, where we produced the first comprehensive look at all three categories. And then perhaps maybe more important from like a stakeholder impact is moving our demographic questions and responses away from that alignment with IPEDS could actually create an additional reporting burden for some of our law schools. It essentially could lead to a place where a law school has kind of two separate tracks of demographic questions and response options that it has to collect from its students, one to report to the state bar and one to report to the U.S. Department of Education. So we brought this discussion to CSBARS in March, and we wanted to really bring the concerns that were raised to the committee because I think they're significant. First was a concern regarding the level of effort and the cost that it would take to update the infrastructure that schools have in place to collect this data. From the school's vantage point, they were concerned about it being kind of underappreciated or underestimated just how much time and cost is associated with updating all of their forms, whether it's online or in person, or paper forms. updating all of their data collection channels, whether they collect through online forms or other methods of just gathering all this information, and even some of their kind of databases and where and how they store all the information that they collect. There was also another concern about the compliance burden. I mentioned the risk of having kind of two separate tracks for data collection, but there's also a sentiment that it already is a large effort for schools to meet our current requirements in the law school compliance reports, and that expanding on the kind of the data reporting requirements would make that burden larger. This is similar feedback to what we received ahead of the last rollout in 2020 through 2022. So these, I think, are just kind of persistent concerns that we've heard in the past. The second concern was just the difficulty of collecting this kind of data. Members really expressed some concern that a number of students or large number of students are already somewhat uncomfortable sharing demographic data. And they were afraid that kind of adding more to those questions, adding more questions or adding more kind of levels of detail could make students feel even less comfortable submitting this data. They also felt that just expanding the number of questions or response options could just reduce the response rate. And when the students don't respond initially, it actually increases the level of effort, because schools have told us that they have to call some of their students and they have to really kind of up their engagement effort to collect the information. And then lastly, because this is difficult, CSBARS members recommended that the state bar should just take on these changes in its registration form, where we collect our own student demographic data. And I just wanted to point out, we are exploring those updates already, but essentially the message from some members at CSBARS was, if this is of interest to the state bar, it should kind of originate through our own data collection channels first.
And before we go further, Ashley, do you have your hand up?
Yes, I do. I'm just giving notice that I'll be stepping away for about a half an hour. Thank you.
Okay, thank you. Go ahead. I'm sorry, Cody.
No problem. And then the last kind of bucket of concerns was just this overall concern about expanding, reporting requirements. And we heard from members, kind of the concern of a risk that our requests for data will just continue to balloon and increase, and that it's enticing to ask for more, but that perhaps the benefits of that additional nuance and additional insights may not justify the costs. Other members, I think supported that, and also added a concern that perhaps some of what is being proposed as far as expanding the questions and response options may reflect kind of more cultural, social, or political trends, and so that there could be a risk that there would be future changes that are kind of responding to an ebb and flow of kind of what is desirable as far as collecting demographic information. And I think overall, what I have presented as what we believe to be the biggest benefit, which is future opportunities, opportunity to do comparative analysis, opportunity to do more targeted like access and inclusion initiatives. There was a feeling among members that those are great opportunities, but that we hadn't yet fully defined like a very clear immediate use case, and that for some of the members suggested that the benefits were not yet clear. And just to add to that, I think those concerns are real. We are interested in this nuance because of the opportunity to have more insights, but we don't know yet whether or not there will be interesting findings. There's a risk that for many of our smaller schools that disaggregating the data even further will actually make sample sizes quite small and would limit the ability to pull interesting insights out. And then I think we have found, in some cases, we collect more granular and more specific information, but when we go to publicly report on our findings, we may find it that it's easier to communicate to the public at the higher level without all that granularity. And so from a reporting standpoint, some of the benefits may not actualize. And lastly, before I turn it to the committee, I mentioned earlier how the Department of Education had added these socioeconomic identifiers for some institutions. We asked CSBARS to weigh in on this as well, because in the past, some of our schools have told us that their student populations are often part or full-time workers. They're often first-generation students. They're caregivers. So there are these socioeconomic elements to their identity that maybe would tell us more about their performance or their access and journey through legal education than just race, gender, and some of these other identifiers. So we presented the two that IPEDS had adopted. One of them is a measure of first generation status, and the other family income. And I think generally the feedback from CSBARS was that the concerns were pretty much the same. Adding additional questions may not produce the kind of value that warrants the level of effort and the cost. So that gets us to today's purpose. And what we are really interested to know from our committee members here is whether or not we should continue to explore this, or whether we should defer, kind of recognizing the level of effort and cost. And if the guidance we received today suggests we should continue to explore it, I think some of the immediate next steps for us will be to first kind of identify a clearer and more immediate use case so we can better communicate the value to our stakeholders. And then I think we would need, continuing engagement with law schools to figure out how to overcome some of those significant concerns that were raised. If option 2 is preferred, which is to defer, we certainly will continue to explore our ability to update our own demographic data collection through the registration form. I think that's an opportunity to assess the value of those changes before rolling out to law schools. And that also provides some time to assess the impact that kind of similar changes have had on other state bar reports. So with that, I'm happy to take questions and also happy to take feedback. As we mentioned, we're really seeking guidance because this is a CVE work plan to better understand how the committee would like us to prioritize this or not.
Comments, thoughts? Judge Reyna.
I just have a question concerning how costs are defined. Did they say, or like how much we're talking about in terms of costs? I mean, I understand if you add additional categories or you have to update things, certainly that's going to be a change that's going to require work. I guess depending on how we use it. I'm just kind of curious how much costs that people were thinking that would be in law schools or CSBARS.
Yeah, thank you for that question, Judge Reyna. I don't think we got a sense of like a dollar amount. I think the sentiment that was shared with us was that the cost would be large. I think this won't help quantify it, but I think it maybe just helps add some extra color. Some of the cost concerns that were raised include perhaps needing, to bring in some IT support to update some of the online infrastructure for collecting this, all the way to, additional either time or staff kind of within the registrar's office to compile all the data. So it's a number of different possible costs, but we didn't get a dollar amount from the schools.
Thanks.
Vince Reyes.
Can you hear me okay, Cody?
I can't, Vince. It's a little bit quiet. There you go.
I generally agree with collecting more data in specific categories, particularly the ones you outlined: race, gender, ethnicity, sexuality, socioeconomic factors. My experience is generally it's an institutional response to say we can't do it because of cost. We have to bring in whatever, we have to change our forms, whatever. But I think that particularly in this society, these are the kind of uncomfortable questions that we need to be asking, but a lot of people don't want to do it. So, for example, just in the breakdown of the Asian category and the Latino category, those nuances can bring a lot of information as to how you can deal with students once they're
in the school, how you may have networks to recruit more students into your schools, because a lot of these schools complain, we don't have this particular demographic, but then to do something about it, I think you need to have data in order to put in some kind of action plan. And those kinds of things take work, and it does take money, it takes a lot of thought, it takes a lot of cooperation. On the other side of that, it may be difficult to pull information out of applicants because they don't want to disclose, maybe even what their ethnicity is. But that has to do with how you approach people, how you educate people, why their data is important. So my sense is that I think it's a really good thing, and I think you put a lot of thought into the reasons for why collecting this data is important. So I hope that that can continue to go. I'm not sure exactly what, if all of it should get approved, but I think the biggest pieces should be seriously considered. And I think it would go a long way to starting the discussions that need to happen and then collecting the data around us to create the kind of action plan.
Kareem.
Yes, and thank you, Cody, for your presentation. So I am at the point of my service here on the committee that I remember this conversation vividly. And so one of the strategic plan components in 2022 was to promote diversity and inclusion in the legal system. And so this is around the time CSBARS was kind of getting under its wings and kind of moving really quickly post-pandemic. And so there was a lot of different things aligning. I'm personally in favor of expansion, and so I agree with my colleague, Mr. Reyes. I'm just mindful of what does the State Bar have to help support the CSBAR's concerns. And Donna, if you could add any additional context to that. Because for the most part, the fundamental understanding of why we went this direction was to really parse the data to the sense that we know who's getting access to our schools, and then who's passing, and then what resources we could provide, or what blind spots were we missing. And so I think the expansion of the data allows us to capture this more. Obviously, we do a lot of studies and research to kind of greater understand our student population. But I think that was where this comes from. And so I understand the concerns. I understand any kind of additional regulation requires a cost, and I get it. I just think this has a potential to do greater good when it comes to access to justice. And so I'm really mindful of that. But I also am concerned that we create too many additional, what is it called? Like regulations, I suppose, are called to the opportunity schools and providing, not as much support that we should. So, Don, I don't know if you have anything, or if we have any new tools, AI, or anything that could help make this more efficient or a better procedure for our partners.
Yeah, so I don't think we have some tools at our disposal that would help the schools collect this data. And I think that's their big concern right now. There are different requirements coming from different places. They have significantly expanded the data that they have provided to the State Bar over the past couple of years. We had a three-year phase-in of additional reporting requirements. And so we are always on the lookout to improve those requirements, to have the data be, comply with everything that we're collecting on the demographics. But I think it is sort of a question now, as you very rightly put it, you're balancing the costs to these opportunity schools versus the benefit that we would get out of receiving the data and being able to parse the data and act on the data. And I think what we were hearing from the schools is maybe right now isn't the time that we need to push on additional data collection, but rather, let's see where other things land and see if there is some more alignment with the data that they're being asked to provide, because certainly we don't want to ask them to provide one set of data, somebody else asking them to provide another set of data, especially with the size of some of these schools, right? Most of our the CALs and the registered schools. Not all, but most are very small. And the more data you get, frankly, you can't really parse it because you don't have, the N is not big enough. And so I think, that potentially waiting before adding additional data requirements might be the sort of the best move. Understanding sort of our regulatory responsibility and our desire to ensure improved diversity, but also understanding not wanting to create extra reporting requirements that maybe there's not a lot we can do with right now because of the small N.
Yeah, and I would add too, on the support front, one way to think about providing support to the schools would also be kind of the next step identified in option 2, which is we can internally at the State Bar continue to explore whether to expand our own collection through the registration form. And, perhaps through that process, there's an opportunity to share some initial findings, insights, lessons learned, best practices. And so, I think that's not necessarily providing support for the infrastructure, but I think it's an opportunity for us to kind of be at the front line, and then we can share some of our knowledge if we defer this and revisit this with the law schools after we've done our own revisions.
Michael.
Oh, thank you all. I think Donna had an excellent word, for this on the idea of balancing. And we saw the prior presentation about the post-exam surveys and how powerful the data was, and that we were able to take this data and then analyze it and then make factual, evidence-based decisions. And if we can't measure it, we can't manage it. But then I think the question that perhaps CSBARS has is, well, manage what? What is this data going to be used for? Why are you asking this? What's going to become of this? And that may be helpful to know on our side of how do we articulate to them and then the students who will be answering these surveys, well, why do we want to know this information? Because we're going to use this to try to improve the program. That bridge and that balancing seems to be where we're having a disconnect between CSBARS and what we're seeking to do here.
Any other thoughts? Oh, Kareem?
Oh, Mr. Reyes had.
Vincent and Kareem.
I don't want to sound so idealistic about this, but I think there's kind of a general stereotype that minority students or students of color are the ones who go back into their communities. And these particular communities happen to be the most disadvantaged in many ways, whether they're first gen or socioeconomic reasons or just outright prejudice that their families have encountered in life. And so it is a balancing act, I believe, and maybe quoting what you said about maybe the bar starts doing a little bit more exploration. But I think for me the thing is, if we wait, how long do you have to wait? How long does it take to change these regulations? It takes a long time. And so I'm just encouraging the CSBARS to kind of look at these recommendations and see how best they can embrace them. Because again, to me, it comes down to the question is, how long do you have to wait? Is money always going to be the factor that prevents things? And that flow of money is something that's going to help the very communities that you're trying to do outreach to. And so it comes back to what Kareem was saying. It's kind of all about justice in the long run. And how do you get there? You can only make so many excuses around money and institutional barriers until you actually can do something about it. I mean, I think it's in the right direction. And I'm not saying that CSBARS doesn't care about it. I'm just looking at how best to find that balance and then move on as quickly as possible.
Yeah, and Mr. Reyes, thank you for those comments. I think they're incredibly helpful with the conversation. I think, number one, I look at it from the access to justice perspective about how we use these different tools to help us create policy and set forth recommendations. I get the idea that additional regulations creates additional cost. My concern is what does delay do? Does delay mean we don't cap? And I'm saying this at a greater level. I don't know the granular of what the expanded data collection looks like. Maybe Cody, you could provide some clarity as to what we are actually expanding, so we could get a more granular idea of what we're going to be omitting for the next time span. But for me, like, I think data is important. You know, I think the way we've been using it has been very helpful for us to create different programming. And at the end of the day, it's about access to justice. It's about public protection. And so the schools receive an accreditation from us, and we have a process. And so I'm wondering how that all aligns together. In my head, it's like, well, we set forth those parameters that we wish to see from our institutions, and we want them to operate successfully. But then I also want to figure out policy-wise how the data allows us to inform the way we make those decisions, if that makes sense, Cody.
Yeah, I mean, I think the clearest example would be those race and ethnicity subgroups that we shared from the attorney census. I think that's probably the best example. What that would mean, or just comparing it to the status quo today, we already collect race and ethnicity data, and we can report on it as we do in like the law school performance report. What the clearest, I think, future use case would be to expand the response options to race and ethnicity questions to include subgroups. That gives us some more nuance, which could then, I think, be used for two things. I think it could be used, to Vince's point, to kind of better understand the population of students and understand if there are unique needs based on unique populations. We don't know what the findings would be, and there's no immediate initiative on that front, but it would open up an opportunity. And then I think the second big opportunity would be if we have those subgroups, again, this ability to do a very clear cross comparison to other reports, such as the attorney census. So right now, if we wanted to look at our student population and compare them to the attorney population, we could only speak at these higher levels of race and ethnicity, such as Asian, Latino, white, Black, or we could be able to add this extra layer of nuance where we could speak to what does the population of, let's say, Chinese students look like compared to our population of attorneys who identify as Chinese, right? So those are probably kind of the most clearly defined use cases at this point. And so that helps maybe help members better understand that balance of what is the benefits versus what are these perceived costs. I hope that at least helps.
So, Chair, I'm sorry, Dr. Bolton had something.
Go ahead, Dr. Bolton. Could we have a presentation that illustrates the purpose of the data?
Cody, did you hear that?
I could not. Could you repeat that one more time, please?
I say, could we have a presentation that illustrates the purpose of the data?
Yeah, I mean, I guess we could maybe speak more to how we've implemented similar changes elsewhere. And maybe what I'm picking up, and I don't want to speak for the committee, but I'm trying to kind of synthesize all this feedback. Maybe what I'm hearing is that members are really interested in better understanding this balance, but they need more information to make that assessment. So maybe our next step is to come back with more information about how these changes have been applied elsewhere, or more information about the specific costs, as Judge Reyna mentioned. Am I kind of gauging the committee's feedback so far accurately, that maybe more information is needed here?
Well, one thing is, to Dr. Bolton's point, I think he's asking for just a basic understanding of why we collect this data. So that's one thing we need. And then Cody, in looking at the two options, I'm not sure I see the difference. They seem to complement each other. what are the options that you're outlining here?
Yeah, let me speak to that first, and then I think I can respond to the first question too. I think the distinction between these options is at how much should we prioritize this initiative? If the committee wants this to continue to be a priority, we will immediately return back to CSBARS. We'll work kind of diligently to get over some of these concerns and come back with a proposal kind of in the short term. I think option 2 is to defer, which is not to say that we can't revisit this discussion, but it's option 2 would be let's deprioritize this. Let's let the state bar explore this type of expansion with its own data collection efforts with the registration form. And, after some assessment of that effort, maybe come back in the future, not probably in this year, we're talking, maybe a multi-year effort to look over those changes and then come back in the future to see if it's something we should pass on to the law schools.
I don't want to speak for other committee members, but it sounds like it's a priority to move forward. I see some nods here. Yeah. Judge Reyna or Michael?
Maybe Cody kind of addressed this. I was just trying to understand option 2. When you talk about the state bar revising its registration demographic data, I was just trying to understand how that works. Is that happening? Would you help in that effort, or is that even happening?
It's something we've been researching but haven't implemented yet. So we want to continue to explore that. That is, every applicant who registered with the State Bar has to respond to our own set of demographic questions to complete their form. So we have the ability to modify that in the same kind of way that we are talking about expanding on the questions and options for the law schools. So like under option 2, the thinking would be, let's do that first internally. Let's see what kind of impact that has. And then we can assess whether we should recommend that the law schools do the same when they're collecting their own demographic data.
But I guess from your previous comments in terms of being a multi-year type of push, or I guess the direction that wouldn't be for that to immediately start happening where we revise, for example, the state bar registration demographic data, you would, in terms of a proposal for that.
Yeah, let me maybe clarify the timeline why I said that. It's something we are internally researching. When I say researching, there are questions about what actual questions and response options we want to pursue. And as I mentioned, we have some references elsewhere in the state bar. There's also kind of just, there's legal questions about what questions we should be asking certain people at certain times. And then also there's an IT component. So we have to then update our forms. There's a level of effort related to updating our own internal system. And then I think there's the third piece, which is we then need to introduce new questions and response options and then actually collect enough data to be able to assess it. And so there would be new registered students. We need to get like a sufficient population there. And, I think there had been some initial discussions to perhaps, ask some population of our current applicants in the system to update their demographic identifiers. And so that would take time, I think, to hit a certain threshold for us to actually have interesting enough findings, a large enough sample, essentially, to say something about the population.
Okay. One more, and then I'd like to move on. Michael?
Yes, just quick. I just wanted to clarify the concern from the question that Cody asked was if the data was free or low cost, I think we'd always want more data. So we've asked for more data, but then we got the response that says, well, it's costly. What I'm seeking is a way to articulate to them and say, well, why do we want this? And to say, well, because it will improve programming, it will include focus of what we're trying to achieve for access to justice, et cetera. That's, I think, the thing that I was hoping for, is that we articulate a response so that when the ball comes back to our side, we can then push it back over and say, well, that's why we want this, and it's worth the cost.
Okay, and that dovetails with Dr. Bolden's question of why are we collecting this in the first place? Cody, do you need a motion here, or do you kind of sense what the committee is suggesting?
Yeah, I think we're gonna go back and get some more information for you all to consider. That's my takeaway. And I know, Chair, that you want to move on. If I could just briefly just say, I think the biggest opportunity in front of the committee today related to this issue is the data that's reported about law school performance. And so I think we will likely go back to CSBARS. We'll talk more about why this initiative could enhance our law school performance report, which is something that's important to the committee when it makes its policy decision. And then I think we'll focus around that and come back with some answers to some of the questions.
Okay, great. We're almost at the noon hour. Cody, do you think you can do 5.1 in the next 5 minutes?
Our updates, our staff updates.
Okay, I'm being asked to save that for after. All right, we're at the noon hour. We're going to take a break until 1:30. Recess? We're in recess?
We're in recess.
We'll be in recess until 1:30. The testing accommodation meeting will occur in this room, and the rest of us are invited to the other room. Thank you very much. We'll see everybody at 1:30.
Bolton. Burns. Cow.
Yes, I'm here. I'm here.
Thank you. Gongora.
Here.
Kaplan, not present. Kramer.
Here.
Lawrence.
Here.
Lee. Maciwala, not present. Montgomery.
Here.
Reed, not present. Reyes.
Here.
Reyna.
Here.
Silva Guzman.
Here.
Smith.
Here.
Yokelson.
Here.
We have a quorum.
Great. Next on the agenda is item 4.7, adoption of the risk benefit analysis for our options as required by California Rule of Court 9.6B, including reporting on cost and efficiency as required by Business and Professional Code section 6046.2.
Oh, Alan, can you turn on the mic?
Action on the form final recommendation to the Board of Trustees and the California Supreme Court on the bar exam starting in 2028. This item is being presented by Chief of Admissions Donna Hershkowitz and Office of Admissions Director, Programs Director Cody Hunanian. So Donna?
Good afternoon. I am going to have, shockingly enough, just a very brief recap for you. And then we'll turn it over to you for discussion. So just to, my system keeps shutting down. So just to give you that a brief recap of where we are now. So in January, the Committee of Bar Examiners and the board were presented with 8 options for consideration of what the future bar exam might look like. That was sort of an expansion from 3 options, and sort of as we were growing and identifying all of the options with greater granularity. You were asked at that time to provide direction for the staff as we put together the draft and then ultimately the final risk-benefit analysis. At that time, the Committee of Bar Examiners recommended that we move forward with the next-gen UBE as the future bar exam without a California component.
the Board of Trustees took that recommendation and said, not quite yet ready to narrow down to a single recommendation. They requested that that risk-benefit analysis include both the CBE's recommendation and a recommendation that was more of a deferral of the decision, right? That we use the questions that were developed by Kaplan starting in 2028, and when the NCBE's multi-state bar exam would no longer be available to us, that we use those questions developed by Kaplan while we wait and get performance data and about the next gen UBE as that was starts to be administered in July 26th through July 28th, that we get performance data, and then we review that data and then make a determination about what the future bar exam is going to be. So with that direction, we staff went away and we came up with a draft risk-benefit analysis pursuant to the requirements set forth in Rule of Court 9.6b. We presented that draft risk-benefit analysis again at a joint meeting of CBE and the Board of Trustees in March. At that time, we got input from the board members and from CBE members about some additional information that they would like either presented to them or included in the risk-benefit analysis. So today, here you are presented with a final risk-benefit analysis that we are asking the CBE to adopt. The risk-benefit analysis does not need to be adopted by the Board of Trustees, so the Committee of Bar Examiners would take the final action on that. And then we are asking the CBE, now that you have the final risk-benefit analysis in front of you, that is the roadmap to drive the ultimate decision of what your recommendation for the future bar exam is. So although you gave us a direction in January, now that you have the complete risk-benefit analysis, we are asking you to make a formal recommendation to the Board of Trustees and the Supreme Court about what the future bar exam should be. The Board of Trustees will take that up at their meeting next month, and then the recommendation, either the singular recommendation from CBE and the board, or if there are two separate recommendations, then both of those recommendations will be presented to the Supreme Court for its consideration. And so with that, I want to just turn it over to you to talk about the risk-benefit analysis, and if there are any questions about that, changes that you think need to be made in order to approve that as a final document, and then to discuss your recommendations for the future bar exam.
Thank you, Donna. Thoughts, questions, analysis? Okay. Good. Julianne?
I'll
Yeah.
start off with one thing. The survey for the graders, I appreciate that being done. I think that was very helpful as far as the analysis. I'm concerned that a lot of them say that they have what seems to be pretty systematic issues with the exam as far as what they saw, to the extent that some said they would not want to be graders anymore if we adopt the NCBE. I think those grader statements should be part of any analysis made. I think those statements are very important from someone, or from a group of people who have actually seen the exam itself. So I would ask that those be made part of the risk-benefit analysis.
Okay.
So that information can be added into the risk-benefit analysis, similar to how it was described in the staff report. And just to make one point very clear, because of how I heard it come up in the public comment, I do want to be clear that there were 12 graders who, I think there were 14 graders who participated in grading, the 14 California graders who participated in grading the next gen beta test. 12 of them were able to join me in a meeting to discuss their impressions. And so I just wanted to make sure that everybody had an understanding of sort of, right, when I said several graders said, it's several graders of those 12. And I just wanted to put that in a little bit of context.
Do we know what several means? 3? 5?
Not everybody weighed in on whether they would continue to grade or not, but certainly I would say probably 3 said
affirmatively said, yeah, I probably wouldn't grade if this were the direction. But there may have been others on the call who felt the same way who didn't say it. So I didn't want to put a number to it because I didn't want to minimize it. But I also want to make sure that you all are not thinking that this is all 100 graders that we have in the grading pool.
Okay. There are a number of hands online too, but okay, Julianne?
Just a quick follow-up on that. Will there be a formal survey done for exact numbers?
So again, there were only 14 people who graded. So I don't know that there would be much of a benefit to doing a survey back to those 14 graders. I felt like the sort of the summary captured that information. We just can't know if it's representative of the full set of graders. And so I just don't know that for 14 people that a survey would be particularly beneficial.
Let's go to the other locations. Michael Cow?
Thank you, Alan. I just had a general question, and I know that this has been written in staff reports, and we've discussed this, and I just want to make sure that I understand. Donna, can you repeat what's been discussed before about what is the timeline, meaning that if we make a decision today, what's the timeline of implementation? And if we don't make a decision today, because several members of the public, including our former chair, Alex Chan, had talked about slowing this process down, what is the timeline with that? I just want to make sure I understand procedurally what the timeline is. There's not real discussion about the risk cost analysis. I just want to figure out about that again.
Certainly. So if we were focusing on the two options that were described in the risk benefit analysis, one being adoption of the next gen UBE, and the other what we're calling in the analysis and in the staff report use of Kaplan. That either one of those, some decision needs to be made today, but the use of Kaplan decision is a slowdown decision, right? It is a decision to use Kaplan through at least 2029, frankly. So it would use Kaplan until we could get data after other jurisdictions go live with NextGen. And as we've talked about before, the large jurisdictions are going on NextGen in July of 2028. The first official deployment of NextGen is July of 2026. So that deferral decision, that slowdown decision, would say, let's wait until the July 2028 exam, at which point we will then collect whatever data we can collect. One of the things that we would certainly be able to know at that point is confirmation that all of the synthetic load testing was proved to be accurate, and that the platform was able to handle the load of all of those test takers. We might also have the ability to look at performance data from other jurisdictions. We might not, but we might have the ability to look at performance data at that point. And so we would be using the Kaplan questions until we came back after we reviewed that data, and presumably in about the same time in 2029 as this year. So, in May of 2029, a final recommendation would go to the Supreme Court based on that review of data for a decision at that point of, okay, now that we've sort of slowed down for a couple of years and we've used the Kaplan questions for a couple of years while NextGen was up and running, while Nevada was up and running, what does the data tell us and what is our final recommendation? But to be clear, you have to make a decision, a recommendation today, because you want the Board of Trustees to consider your recommendation in suggesting something to the Supreme Court. We absolutely need to provide public notice of what the July 2028 bar exam is going to be in July 2026, because no matter what we do, the July 2028 bar exam will be different from today, because today we're offering the MBE and that won't exist anymore. And so we have to give notice. So we have to make a decision on what that notice is going to be that we're going to be doing in July of 2028. So the slowdown option is encapsulated within the slowdown approach is encapsulated within the use of Kaplan option.
And then, assuming hypothetically, if in 2028 the committee recommended next gen and the court accepted it, it would still be 2 more years before it would be implemented. So we need to make that clear.
Under this sort of deferral of a decision option, then the earliest that anything would be implemented would be July of 2031.
Because there's a 2-year notice requirement.
Exactly.
Okay. Ashley Silva Guzman.
Hi. I think my question would be more centered around the lack of a California component. I'm not the hugest next gen fan in general, but especially without the California component, how would we build or continue to build a bank if we decided to pivot, years down the line, if next gen just doesn't work or it's just not fitting for our test takers? How would we continue to build that base of like essays and PTs if we're not doing a California component?
So I think there are kind of 3 questions embedded within there.
Sorry.
Because, no worries. I wanted to be able to tease this apart. So one, you can all recommend next gen with a California component. Let me be clear about that, but that is certainly an option of yours. And as the staff report talks about, should you or the board recommend adopt that option, or frankly, even if you don't, we recommend asking the court, if the court is inclined for there to be a California component, we would recommend that the court tell us what the subject areas are that they would like to be included in that California component, and which one, and if they are just testing California law or if they're testing laws of general application. Depending on ultimately, so let's assume that happens. Depending on how we develop that California component, it may or may not be providing us essays and PTs. It may be, the staff report talks about an option where it is really about familiarization with important components of California law. And it is not about testing minimum competence in those areas. If the committee feels NextGen's already tested minimum competence, we are committed to making sure people know key things about California law. So we want them to be familiar with it. We could provide resource materials, as some states do, right? Develop a comprehensive outline with resource materials about the areas of California law we want them to know and that we will test on. We could do an on-demand multiple choice test, right? So that is a great option for testing a California component. But actually, it doesn't get to that issue of we're still not building a bank of essays and PTs. Now, if we ultimately, see, this is why it's a 3-part question. If we were to ultimately decide that, you know what, we're doing our analysis and we think that the practice of law has evolved in California such that what is needed for an entry-level lawyer in California are different subject areas than NextGen is testing, we want to develop our own exam. There is nothing to say that would necessarily include essays and PTs. So there was no direction from the Supreme Court's October 2024 order other than sort of the content areas and that it be focused on applied skills and not memorization. But there was a big TBD on the question type. And we had talked at the time about being really innovative and doing simulations and a variety of other things that might test. Doing California component may or may not sort of set us up to have some questions in our bank that we could then utilize for a future California exam if that is a direction that we go in. Using Kaplan as the bridge while we're figuring out if we end up using those same subject areas, using some of those same question types then yes, that would be the one option that would keep a developing bank of questions that we could draw from if in the future we were going to be using the same subject areas and the same question types.
And just a quick follow-up question. So if we move forward with the next gen, it goes up to the levels it needs to go to. Would the Supreme Court, once it got there, also kind of give us feedback about whether or not what would happen with those remaining, I think it's maybe 3 topics that aren't covered by the next gen, or where would that feedback come from?
So yes, that's exactly what I'd be suggesting, that we would, in the petition, ask the Supreme Court to identify what are the subjects that it would like us to include in a California component if it wants us to do a California component. As you identified, there are employment law, administrative law and procedure, and
remedies.
Community property. Family law is going to be tested, but community property not currently going to be tested on next gen. Those were areas that the Supreme Court had wanted us to test, so they could direct that we test those. Also, currently, and we talk about a California exam, but the truth of the matter is we don't test a lot of California law currently, but we do test some California civil procedure, some California professional responsibility, California evidence, and of course, community property. So the Supreme Court could say, in a California component, I want you to test these subjects. I want you to test employment law, and I want you to test laws of general applicability as well as California, or just California. They can say, I want you to continue to test California civil procedure, right? That's where I think we would very much benefit asking the court, if they are inclined to adopt a next gen with a California component, to give the committee that information so we could take that and over the course of the next year or so, develop content maps in those areas and a recommendation for the Supreme Court about the question types and the mode of delivery of that California component. And so again, to be crystal clear, if that's the direction to adopt next gen with a California component, the California component would trail by a year. And so we would be able to adopt next gen without a California component in July 2028. It would be probably July 2029 before we could roll out the California component.
Josh.
I want to say first that I support the staff's risk-benefit analysis and think that we should adopt it. Second, I shared a document with Devin and a few other staff members that includes a short rundown that I hope you'll bear with me while I go through with you guys.
I'm sorry, Justin, is your mic on? I want to make sure everyone can hear you.
I think it is. Can you hear me?
Ashley signaled yes.
Okay, great. I sent a short document with 5 points and a couple sub-points under each that I'm hoping to go through with you guys, and I won't take up more than a few minutes. And at the end of that document is a substitute motion to replace the motion that we move forward with next gen. And
Actually, Josh, if I can interrupt, there is no motion pending right now. So
Okay.
that would just be your motion.
Okay. I'd be willing to consider and I think perhaps it is for the best that we discuss before moving on this, before I move to pass this motion when it is shown to you guys. But I'll run through the summary of why we should absolutely not go with next gen first. The first point is that in February 25, we rushed to contract with a trusted vendor in Measure Learning. And we even saw quotes from the CBE presentations that with huge numbers of adopted, I would say, anecdotes from customers saying that this was going to be an effective vendor. And we're seeing something similar with NextGen. They claim that they sell to a bunch of people and they're this giant organization, but that doesn't necessarily mean that there's going to be a smooth rollout. The second point is that particularly after February 2025, we owe the public and profession assurance that we selected the absolute best exam after complete due diligence on all options. And sticking with Kaplan would give us the safest route to do that because it would mimic the mold that we currently see now, and that's reflected in the motion that I drafted. The third point, that's the second point. Like I said, it's going to go quick. The third point is that we do not have crucial performance and technological data on NextGen. We don't have any analysis of the content or if it meets our standards and goals. We don't have any information about minority or gender disparity pass rates or disability accommodations. And data will be available in the 2028-2029 window when we have to make a permanent decision or a more permanent decision. There's also not enough information on the technological fail rate during large-scale delivery. We've heard the number 2 to 3% thrown around some for next-gen administrations, but that would equal about 400 failed laptops in California based on the average test taker numbers. We heard the fourth point that I put up here over and over again from the public commenters, and I hope that you guys will consider the ratio of the number of people who wrote into us and spoke to us relative championing Kaplan or at least not championing NextGen or speaking out against it. It's like 10 or 20 to 1. I mean, the law professors, 8 of them, and only the ABA law professors now signed on to a letter in a written public comment, but the other hundreds of pages of public comments were all in favor of Kaplan and staunchly against NextGen. But the fourth point that I put into this short summary is that on page 14 of the staff report that we all have access to today, it's the same thing we've heard over and over again today already, and I apologize for being redundant, but the graders have said they're going to quit. I mean, and a St. Louis University law professor even called in and said, absolutely don't do this. So did Alex Chanton, our former president. Or I guess the chair. the former chair.
He'd be happy to be president.
Right on. And so the fifth point is that we do have performance data and metrics on Kaplan drafted questions, which kind of lends credibility to the second point that I made about the duty that we owe to the public to make measured, cautious decisions. On the staff report on page 6 is quoted, there's a quote as stating that Kaplan developed multiple choice questions and showed high reliability and strong performance of the questions and validity of the exam. Nonetheless, the State Bar has added significant rigor to the content validation process of the Kaplan, and this is the bracketed part that I'm adding, of the Kaplan questions, to ensure that all items are reviewed so they appropriately test for minimum competence, are free from bias, are consistent, and are legally accurate. And staff repeatedly has assured that the Kaplan, and so did the Kaplan vendors when they spoke to us, that the questions will not substantially modify the training or the preparation required for passage of the exam. And that's critically important because that means that bar examiners, like the broke ones that we were talking about before who can't afford to pay for new bar prep courses, can use old materials to study for these questions because they are going to mimic the style, the form, and the tenor, the rhetoric of the current types of questions. So that brings me to perhaps the most complicated part of this document, and I hope that you guys will consider it because Jean helped me write it. She helped me rewrite it, so it was more comprehensive. The first one that I had was like 20 words long, but this one essentially says, let's go with the Kaplan developed multiple choice questions, or let's go with the use of Kaplan as a bridge up to and through 2029. And I think that we should continue to discuss that, but I'm going to move for that once we are satisfied with the discussion. And Devin, would you mind putting that on the screen, the motion draft?
And just to clarify, the proposal is to replace the last resolved in the resolution that's in the staff report with this one that Devin will be sharing.
Yes, thank you. Thank you very much.
Thank you. Thanks, Josh. That's very well thought. Let's take a moment and look through this.
Perhaps somebody, Josh, if you could read it out loud.
Yeah.
Yeah, sure. I can't actually read it. Taking it this whole time. Further resolved that the Committee of Bar Examiners, now having considered and adopted the risk-benefit analysis as required by California Rules of Court, makes a final recommendation to the Board of Trustees for their review and approval to adopt the use of Kaplan option described in the risk-benefit analysis. Specifically, the Committee of Bar Examiners is recommending that, one, beginning with the July 2028 bar examination and continuing until any future order is issued by the court, the State Bar administer a bar examination in accordance with the court's Administrative Order 2024-10-2101, which contains 200 multiple choice questions developed by Kaplan Exam Services or another qualified vendor, as well as 5 essay questions and 1 performance test, both of which will be developed by either Kaplan, another qualified vendor, and or the State Bar, and tests the subjects currently tested. And 2, that this recommendation be advanced to the Supreme Court for its approval. And it is further resolved that the Committee of Bar Examiners defers making a decision on an alternative to the California Bar Examination as set forth in the resolution above to 2029 or a date thereafter, recognizing that any potential modifications to the bar examination must comply with applicable law, including the notice requirements set forth in the California Rules of Court and the State Bar Act. Staff is directed to collect operational and performance data about the performance of NextGen UBE and other alternatives to the extent possible to help inform future decisions relating to the bar examination.
Okay, we understand that's going to be a motion.
All right.
All right.
To confirm, this was to replace the last further resolve.
Yes. Do we want to take a second on that right now or continue discussion?
You can take a second on it.
All right, let's take a, is there a second for this?
I'll second it.
Kareem?
Yes.
Okay. Paul?
When I consider public comments, I don't weigh them by the volume of comments in one direction or another, but by the merits of the arguments they make. I have a question about the proposed motion. The administrative order, wasn't that the one that said to adopt the bar Blue Ribbon Commission? So continuing, that's not the proper thing to refer to.
Not.
It's a different one.
Sorry, the order referred to in Josh's motion is the order that the Supreme Court issued in October of 2024, where they removed reference to what the bar exam would contain. It used to refer specifically to the MBE, and that was the order that permitted the State Bar to utilize Kaplan questions instead. So it removed reference to MBE and just says 200 multiple choice questions. So that's the order that this is referring to.
Okay, so this is not saying adopt the current new California only exam. Okay.
Correct.
All right, thanks for that. The staff report recommends that we recommend NextGen without a California component. And one of the reasons cited was lack of bandwidth to be able to develop a new component in time to give 2 years notice and have it ready in July of 28. I wonder though, if we, as Donna was alluding to, I think a little while ago, if we accept that NextGen can determine competence, and the goal is really just to make sure that new lawyers that start practicing in California understand the differences, could we build that, for instance, into the new admittee training that's required? If it comes in that nature, does the 2-year notice rule apply? I would think it would. If we have a multiple choice test that you have to pass before you can be admitted, I guess, that probably the 2-year rule applies to that. But if it's simply baked into the training, that would give us basically 2 years to develop that. And I assume staff's bandwidth is going to improve, say, in a year from now.
So let me make just a couple of clarifications. Staff is not making a recommendation the staff resolution incorporates the recommendation that you all made in January and indicates you are free to make whatever recommendation you want. For ease of putting something on paper, that was in there. The reference to staff resources was about continuing to develop the other court order you were talking about, the new bar exam, continuing to explore that while we are rolling out Next Gen and possibly exploring a California component. So those were two clarifications. In response to your main question, the new attorney training, as you say, is not a prerequisite to admission. You have 12 months after you've been admitted to take the new attorney training. Could we pass a rule that expands that and say, in addition, you are required to review these resources and take this multiple choice test in that first year? Absolutely. That, and build something bigger into the first year requirement, right? Into the new attorney training. That is not a prerequisite to admission. I don't think that would require the 2-year notice. And so, yes, so that is something that staff could develop over that 2-year period, a much more robust new attorney training requirement. Or similarly, you can recommend adoption of Next Gen with a California component, understanding that the first thing that would roll out is Next Gen without a California component, and then a year later, presumably a year later, the California component would roll out. So those are all options in front of you. You could recommend it as an expansion of the new attorney training, which wouldn't require 2-year notice, or you can put it as a requirement to entry, which would sort of be an attachment to the bar exam and therefore would require 2-year notice.
Okay, thanks. And presumably that would also apply to lawyers from other states. If we, for instance, it could be a requirement of reciprocity or a transfer of a score from another state.
Certainly.
Okay, so you've said you don't have the bandwidth to work on the other form of the test.
Right.
And that would be, assuming we adopted Next Gen, that would be much more money down the sink. Okay. Yeah, I can go either way. I want to ask, though, for those who want to wait, note that would delay our move to a new test package that is considered to be more closely aligned with the skills and knowledge thought to be important for new attorneys. So I wonder if those who criticize our current bar, who did in the lead up to the Blue Ribbon Commission, as out of touch with the realities of modern law practice, relying too much on the famous phrase, rote memorization of doctrinal law, rather than the demonstration of skills necessary to competently advise and represent clients as a newly minted attorney. Are they really willing to wait another 5 years to get to that point? Or perhaps 10, if we then decide the Next Gen isn't going to work for us and we have to develop our own? I really have grave doubts that we can design an exam of our own at a lower cost than the Next Gen, whose development costs can be amortized over a larger applicant pool. They've been at it for quite a while. The state bar, whether using its own staff or consultants, is not a low-cost service provider. Probably not even a moderate cost service provider. To a degree that you don't have the bandwidth to do 2 separate versions of an exam at once, supports that conclusion. And then I had one question. Maybe it's too speculative, but I'm wondering what staff sees as the other necessary implementation decisions that we would have to make in order to have Next Gen ready in July of 28. Things such as transfer of scores, especially. And I'll observe that with the graders, I could see why some of them would be less satisfied with grading the next gen exam because it consists more of short answers to questions, maybe an essay or two, but it's a different animal. And also they won't have as much control of it. Right now, they develop the questions, they decide what the proper answers are, and allocate points and scoring among the different components of a complete answer. And all of that's going to be dictated to them from the national conference. So some might find that less satisfying, and frankly, I might too. But I don't know that that can drive our decision. It doesn't for me.
And I would note that at least a couple of the graders in that conversation had raised, and someone actually said, we use the term rote memorization as if it's a bad thing. I don't see what's wrong with that. I think that's what we should be testing. And we shouldn't be testing skills because skills are what you learn in entry-level practice. Now, no matter what route we take, that's already something that the Supreme Court has agreed. They want to test more focus on applied skills and not on memorization. And so that was just sort of a fundamental disagreement with sort of the overall direction that was taken, right? And so this is, right, these are, 12 attorneys who are sort of thinking about this exam, who think about the exam a lot more than a lot of other people. But yes, I think some of the rationale that Member Kramer raised is certainly a fair assessment there. There was a question though in there that I was supposed to respond to.
Well, going forward, what do we have to do?
Yes. So we would have to do standard setting. The NCBE has come up with tools that would assist us in setting, that assist every jurisdiction in setting the passing score. That's what standard setting is. So we would need to work with our psychometrician, look at the tools that NCBE provided, see if that is helpful in our determination. States who have adopted NextGen, I think we're up to 50 at this point, jurisdictions that have adopted it, are rolling out their pass line. So we would need to roll that out. We would need to make a determination on portability. We may need to work with the legislature on portability because there's a statute which suggests that attorneys, out-of-state attorneys need to take an exam. So we may need to work with the legislature and change that statute. Then there's going to be process. The exam is a very different exam than we have, and so we are going to need to look at our processes, change our manuals on what it means to proctor the exam, what the workroom looks like. And so there's going to be a lot of administrative prep work to be done in order to effectively deliver the exam. One of the challenges of the fact that we all offer the exam at the same time is what I really want to do is send a bunch of my staff to different jurisdictions in February and July of 27 to observe. But that means they're not available to proctor our own exam. So we're going to have to figure out a way to do that, and we will, because we want to learn from what other jurisdictions are doing as well. So there's just a lot of information because it is, as a computer-based exam, things will be done differently. In most cases, more efficiently because we are not shipping hundreds of boxes of paper and materials down to workrooms in all of the exam sites. But we'll have to learn new things. We've got proctors who've been proctoring for 30 years, and we need to make sure that we effectively train them on what this exam is like and that it's not going to look the same. So there will be a lot of process steps, but the biggest picture really is standard setting, decisions about portability, and then statutory changes if the direction is for portability.
Sorry, Alan, I just have one more comment about the motion. I think we shouldn't say we're not going to revisit it until 29. We should give ourselves some flexibility. So if it turns out, for instance, to be really a good thing, we might want to adopt it earlier or get the ball rolling earlier. And so when we say 29, we maybe are signaling to the world that they can just, forget about us for a while. And maybe we should say no later than 29, we'll revisit it or something like that.
Procedurally, there's no motion yet, but when the
Oh, okay.
motion is made,
No,
you can
they-
offer
No,
a
there
friendly.
is a motion.
Oh, is there? I'm sorry.
And it
There's a
was
second. I'm
seconded.
sorry. Would
So
you? So
Josh
Josh,
would have
do you
to
want to
accept it.
accept that friendly amendment?
It's up to Josh.
If not, it would be a separate motion.
You're good with that?
Yeah.
Okay.
And so just to put everything on the table, what that would mean is that we will continue moving forward with re-content validating all of the questions in the multiple choice questions that Kaplan had provided. We will send them all through a subject matter expert review. We are receiving essays and performance test questions from Kaplan. Those will go through content validation. So I just want to make sure that everyone understands that there is work that will be involved in that option that requires us to ensure that we have questions ready for these exams that are up to the quality that everybody expects them to be.
Okay.
Done.
Done. Okay. Michael Lee, then Michael Cow.
Observation question. I forget to make this complicated, but it is what it is. Don't want adoption of the next gen.
Is your mic on?
So observation and question. Does not adoption of the next gen exam without the California component set us up for a policy problem later as to reciprocity? Because if we only test next gen and I take Florida and I pass next gen in the Florida component, I say I scored far above the California cut score, why don't you take my exam? And we say no, and they say it was literally the exact same exam, tested the exact same month. I just wasn't sitting in the borders of California. Why did you say no? We have a policy problem. And so I know we're conflating the reciprocity and the choice, but it seems like we sidestepped this problem with Kaplan for the attorney's exam and for reciprocity. We said we have an exam, it's Kaplan, there you go. And we don't have to go down that policy direction.
So isn't the short answer to that the legislature doesn't allow, the current state of the law doesn't allow reciprocity?
I suppose we could shrug and we could just say that and just say, well, the California does what California does. I suppose we could say that, but that seems like a kind of an odd policy that we just say, yeah, we just don't, even though it's exactly, literally the same thing.
So, this would be the first time that we would be offering exactly the same exam. And there is a bill moving through the legislature which would direct that we adopt next gen. And so, I think you're making an assumption that the legislature wouldn't want to make this change. If they are directing adoption of next gen, then in all likelihood, there would be they would want to make that change. And the Supreme Court obviously would need to agree with that. But yeah, I think to the extent that we are delivering the exact same exam, then yeah, that is a much harder question to
Just say
answer.
that's a little bit of a component of this, is that it's there.
I think it's in part, though, it's one of the reasons why certain people are advocating for next gen is because of the portability and because you can take it in Florida, and then if you get hit the passing score that's required in California, if we had it, then you could in a more mobile society, you take that score and you can move it to California. And then if there is a California component, then you would just need to sit for that.
Yeah, but that's the distinction, that without the California component, we have a more significant problem. If it was next gen with California component, less. If it's Kaplan, even less. It's just, that's simply the analysis. It's not leaning one way or another. That's just simply the way it breaks down.
I know. Okay. Michael Cow.
Hey, Alan. Donna, I have a couple questions. The first one is, can you remind me again, because I know we've been talking about this in multiple meetings, can you remind me the experience level that Kaplan has in creating questions for bar examinees? And then what other jurisdictions have they created exams for? Can you remind me again, Donna?
So I believe Kaplan is primarily a bar prep company. So I do not believe that they had created bar exam questions before. Keep in mind, right? Most jurisdictions have used the UBE, the Uniform Bar Exam, or at least the multi-state bar exam, the multiple choice questions, as we have used since 1972. So Kaplan, I think, was known as a bar prep company, but this was their first foray into developing questions for a bar exam.
Okay, so that's my first question. The second question I have is, and I'm trying to make sure I understand the motion on the floor right now, is that the timeline is that the motion says that Kaplan would be the pathway we would go. Then we would assess what next gen in Florida, Texas, and New York results are. And then we would decide again if we want to stay with Kaplan, or we find that Kaplan is not as good or next gen is better, however you want to frame it. And then potentially we may pivot from that and then go the opposite direction. So for students who are in law school in this next 5 to 10 years, they may go from studying Kaplan questions to may going to next gen in just a quick pivot of every 5 to 10 years. So is that interpretation possible?
So I'm going to sort of let Josh talk to most of your question. The one thing that I would clarify is there hasn't been any discussion where returning to Kaplan is the permanent decision. It is a temporary decision until we do something else. So under Josh's motion, that something else could be going to next gen, could be going to Nevada, could be deciding we need to develop a full-fledged new California exam along the lines of what the Supreme Court ordered in October 2024. But Kaplan had never been envisioned as a permanent solution.
Okay, so actually, thank you for that clarification then, because what it sounds like then is that if Kaplan is just a temporary bridge, regardless of whatever decision we make, then and you know, I'm here to represent, I guess, the public, and like I've said before, the public would not just be all of the residents in our state, but also the public would be our students who are in law school. Is that it may be challenging for them to know that whatever they learn in these next 5 or 10 years, that they may constantly have to pivot for a new exam. And I guess as an examinee, I would feel apprehensive that we would have to keep on changing our law school curriculum, or the examinees would have to keep on changing what they're studying depending on how quickly we're pivoting in the next 5 to 10 years. So I guess I may be vocalizing what my apprehension is if I was a student right now. And so I guess, Josh, my question is that if Kaplan is a temporary bridge, as what Donna has said, then what happens then, Josh, if we find that we won't stay with Kaplan permanently as a student? I mean, I guess that's my question to you then, Josh.
Well, I think it's a reasonable question. My immediate reaction during I think the first half of your explanation of the question was that law school curriculum is not a direct preparation only for passing the bar exam. And the 3 months that most students spend studying for the bar exam is the period of time that they target preparing to pass that exam. At least that's how I did it. I imagine that's how Julie did it. I'm guessing that's how Paul did it back in the day. And and so law school curriculums are not going to, and so.
On stone tablets.
And so I would say that I don't think that law school curriculums are going to shift dramatically regardless of which exam is administered, even if a new exam was administered every year. And we started cycling vendors through a random number generator because there's a 3-month period of time that most applicants spend studying for the bar exam unless they're working full time, in which case it might be a 6-month part-time window. So that would be my answer.
And Kaplan is the status quo. It's not a change from what we do now in any meaningful way.
So I would note that the law schools have argued very differently from that point. And one of the things that I know that exists now in law schools that didn't exist when I went to law school with Paul in the Stone Age was that law schools have academic success and bar preparation programs. There is curriculum that the law schools have said we would have to change curriculum if depending on what the bar exam is going to be, and so that would be a change. I don't know, Laura, if you might have some insight having taught bar prep at McGeorge in the past.
Yeah, so I did teach bar prep prior to coming to the state bar for 15 years, and that was through the school. It was an accredited course, and in fact, it was a required course for the lower 50% of the class. So they do change it. We had to shuffle when it switched from a 2-day to a 3-day. We had to have 2 courses running concurrently for those graduating in February, which would have been the 3-day bar still, to those graduating in July. And I can only speak to my experience at the school I was at, is that they do watch. Part of our curriculum there was we were required to take every bar course tested subject. Those were required courses at my school. And they would monitor and watch for those things. So a lot, I do say it has changed, and I was in law school mid-olden days, still a 3-day bar taker, but a lot has changed in the sense of schools really do actually are looking to bar prep, at least the schools that we work with regionally in the area.
You know, it's funny, when I was in school, there was a resistance to bar prep. Exactly. Judge Reyna.
Yeah, I just have a question with respect to the criticism by bar graders of Next Gen. And that is, I thought if we go with Kaplan, which I understand Josh's motion to bridge, I thought there was some criticism of, or called the criticism Kaplan questions. And in anecdotal conversations with some bar graders, I thought I had heard some criticism just also of even development of essay questions too. And so I'm just wondering, Donna, if you have any information. I know we're, in some ways saying no Next Gen, in part, small part, 12th graders or whatnot that have criticized, but I'm wondering if there's that same concern about Kaplan, or if there's this thought that with 2 years, to bridge for the July 2028, we can get a good exam and not have anything near what happened in February 2025.
Yeah, so to back up a little bit and remind folks, as folks have said, obviously the vast majority of the challenges that were experienced in February 2025 were about the administration. However, you all heard at meeting after meeting from a group of academic success and bar preparation law school professors, among others. There was sort of a group of 8 or 10 or so who raised criticisms about the content. Now, their particular knowledge was about the student guide and the faculty guide, which we had published, and they identified what they believed were errors in the content of that. They also had anecdotal information from their students who sat for the exam and saw the 200 questions that were tested. And then we had survey results from students who said who responded to questions about, whether the content was similar to what you had studied. There were those who said, no, it wasn't similar to what I had studied. There were some who said that and I don't have the statistics in front of me, but that that it seemed like that there was no right answer, or it seemed like that there was more than one right answer. We saw by asking the same exact questions in July 2025 when we administered the MBE that no matter what, you get survey respondents who indicate the lack of clarity of the multiple choice questions, but there was a significantly reduced percentage of survey respondents who said that for the MBE questions than they did for the Kaplan questions. And so it was in response to what we heard from those law school professors. We went back and we looked at the study guide and the faculty guide. We reviewed it and Kaplan reviewed it. We had a subject matter expert look at it. We asked Kaplan to replace some of the questions or some of the responses. And there were some that they agreed to replace, though they disagreed with the law professors that they were unclear or wrong, but they, as a sort of good partner, agreed to nonetheless replace the questions. And there were some that we felt were wrong, and so those were replaced. And it is also why we have created this much more robust content validation process and subject matter expert process. We have faith in this new process we've created, but it has not launched yet. And so we have not sort of had that experience. We are very close to launching it because we've continued to move forward with it because we don't know if we're going to need it or not. So we're ready to go pretty soon with that. And so that will give us a lot more information, frankly, that more robust process about the accuracy of the questions. And, our hope, obviously, is that the new content validation panels will find, and the new subject matter experts will find the questions completely accurate, completely clear, not needing any editing. But, right, that's obviously our goal. Whether that is going to be what proves to be true, I don't know. Under the contract with Kaplan, they are expecting that when we do these content validation and subject matter expert reviews, if we have changes, through this iterative process, we'll send them back. They will revise them. We'll take another look at them. And so we are certainly hoping and expecting that we're not losing any questions in that process, and that all of those will be validated. But there were complaints about those questions. Up until now, we have only tested California essays and performance tests that were developed through our old process. We have not yet tested we have not yet content validated any of Kaplan's essays or performance tests, and so those would go through the new process once that's launched.
Donna, can I add one layer to this too? Because you started to touch on this for a second. There were comments about the accuracy and content of the questions themselves, but Donna started to touch on there was also elements of our survey that was perhaps more about the test taker's perception of the question. And in the risk benefit analysis, we have a table dedicated to predictability of the exam. And I just wanted to also put back out there, the test taker's perception of the content will be in part based on their expectations, based on their preparation. And for the use of Kaplan option, we identified that one of the benefits was that as Paul noted, the exam content and design generally is the same, so it's familiar to test takers. On the other hand, the Adopt NextGen option, one of the benefits we identified was the fact that option comes with the robust national marketplace of bar preparation products that test takers will often use. And I think this goes back to even our survey results that showed, like, I think 2/3 of test takers use some sort of bar preparation material. So I just wanted to put out there as well for the committee to consider. Part of the reaction to the questions is this idea of predictability, and predictability is going to be impacted by either a test taker's familiarity with the kind of the overall design of the exam, and also familiarity based on their bar preparation materials.
Okay. Other comments, questions, thoughts? Okay. If there are none, our member Christopher Reed could not be here today, but he left a, I was going to say a short, but it's actually a little bit lengthy, statement that he'd like the committee members to hear. So I'm going to read that into the record now. Statement for the record of Christopher Reed, member, Committee Bar Examiners, April 17, 2026. Item 4.7 of today's meeting calls for a final recommendation to the Board of Trustees and in turn the Supreme Court on the bar exam beginning in 2028. The resolution as drafted would recommend adoption of the next gen uniform bar exam without a California component to be administered beginning in July 2028. Obviously, Chris didn't know about the subsequent amendment. I am unable to attend today's meeting due to a prior commitment that predates my appointment to the committee, but were I able to attend, I would vote in favor of the resolution as drafted, and I think he means as previously drafted. I continue to support an admissions process that more properly aligns with the actual practice of law, and I remain hopeful that California moves in that direction eventually. That said, I am unpersuaded that we have the capabilities or resources required to implement such a process properly and reliably within the time constraints imposed by the National Conference of Bar Examiners, withdrawal of the multi-state bar exam from the marketplace, and the notice requirements of Business and Professions Code Section 6046.6. The consequences of getting this wrong for applicants, for the profession, for the committee, board, and court are too significant to accept that level of risk right now. I do not approach Next-Gen UBE without reservations and recognize that it too comes with its own risk and uncertainty. Still, I believe it is the safest and most prudent course for the near term, in part because we are not leaping into the unknown alone, with at least 48 other jurisdictions making the same transition. Any implementation problems that arise quickly will generate enormous collective pressure and real market incentive to develop solutions quickly. If something goes sideways, we will have company and the infrastructure to find fixes fast. That kind of support system simply does not exist for a fully independent path. The February 2025 exam taught us what that looks like in practice. I hope the committee votes to adopt the resolution and advance it to the board and the Supreme Court for their approval. Once this decision is behind us and the immediate time constraints are lifted, I look forward to continuing the conversation about longer-term reform and what a more ambitious, California-specific, and hopefully more practice-oriented approach might one day look like. I see this as a pause to a more fulsome discussion about the future of bar admissions in California and not a door closing. And that's Chris's statement. So with that, do we have any other discussion, thoughts, comments? All right. Michael Lee.
Just a minor question. Just in the original proposed language of the resolution for the recommendation, at this time, there is insufficient time to make a recommendation to do next gen with a California component. Is that correct?
Donna?
You can make that recommendation. There's insufficient time to roll out the California component by July 2028, but you can certainly make the recommendation that we do without in July 2028 and that we develop the California component in the following year.
Okay, very good. Thank you.
Okay.
I want to make sure that we capture in the resolution, and this would be, I'm speaking for Julianne, but it's sort of a friendly amendment for Josh's consideration. In the first resolved, that that exists in the staff version, that says resolve that the Committee of Bar Examiners pursuant to California Rule of Court, Rule 9.6B, adopts the risk benefit analysis attached here to as Exhibit A. I think that would end with as amended to include a discussion of the input of California graders. Yes.
Josh? Yeah. All right. Can we put the resolution, Josh's resolution, on the screen? Yes? No? Coming? Here we go. All right, so this has been moved and seconded. If there's no further questions or discussion, I'll ask Devin to call the roll.
Bolton?
No.
Burns? Not present. Cow?
No.
Gongora?
Yes.
Kaplan? Not present. Kramer?
No.
Lawrence?
No.
Lee? Masiwala? Not present. Montgomery?
Yes.
Reed? Not present. Reyes?
No.
Reyna?
No.
Silva Guzman?
Yes.
Smith?
Yes.
Yokelson?
No.
With 4 ayes and 8 nays, the motion fails.
Okay. And then I think procedurally, there's the original recommendation of staff. Is there a motion for that?
I'll move the staff recommendation, but with, modify it to include a California component. And,
Can we turn on the mic?
oh, sorry.
Thank you.
Take the staff motion, but modify it to include a California component. And if the component cannot be announced in time to be effective in July of 28, that information about the differences in California law be incorporated into the new admittee training program. Donna, if you can provide the correct name for that.
The new attorney training, NAT.
Okay. That way, if we can get it, we may have to have a transition period where it's informational rather than a test. And that'll leave us time to decide, because how we want to do that, I think we need to talk more about. But we can be on record that we want to do something.
Okay, Devin, I'm having difficulty rejecting the strikeout of that last result. So if somebody can do that, I can insert things, but I can't reject. To clarify, what I think I heard you say is adopt next gen with a California component. If that California component cannot be adopted by July 2028, which it can't be with the notice requirements, to develop to expand the new attorney training to include something like a California component. But it also sounded like that at the same time, you wanted us to be developing a California component.
Well,
am I hearing that correctly?
How about let's reword it. Let's say adopt it. Let's have a, let's leave it as is, just next gen without California. We'll add a paragraph to say, and direct staff to work on the outlines of a California component to be added to the bar exam as soon as possible, and in the interim period to be included in the training. Does that work?
Yes, I would recommend adding the language about directing that we inquire from the court about the subject areas.
Okay, yeah, have the court confirm to us the subjects they wish to be covered.
Yes.
Do we want to suggest the ones we think, or?
I don't think we've had enough discussion about that to
Okay.
really do that thoroughly.
I just added the second resolution of everything at the bottom.
Because this way the world is on notice that it's coming.
Okay.
And so schools, especially if they're focusing on training people, helping people be ready for the bar exam, they know not to just sort of, put community property in the wastebasket. Not that a California school should, but we're also dealing with, all the way back to the Ivy League schools.
I think by putting it in the petition though, to get the feedback from the court as Donna recommended, that will, when they reply to that petition, hopefully that then is included in whatever their answer is to what we submit
And
to them.
staff's homework,
Huh?
and the work staff has to do them. Yeah, it's kind of implied, isn't it?
Yep.
So we're amending the last word. Confusing how it's showing up there.
This is the original resolution, and then at the very end, your further resolved was added back. That was originally replaced with Josh's to further resolved, and then you had this additional at the end of Josh's.
I think we would go back to the original
Yeah.
and then add a new further resolve, so I can cut and paste, and I'll show it to you, Paul, and you can make this, if this covers it. But Devin, I would keep Josh's for the
Yeah,
record,
okay.
Because I was voted on, if we can just it's the original that was contained in the staff report,
Mhm.
and then I can add to that.
Okay.
So Jean, you're putting that in?
I'm attempting, and then I'll see if I've captured it.
This will be both connected in. Yeah, so reduce from multi-state for February, and in July we switch to the next. Do I look up your shoulder, Gene?
Sure. Like the pressure on something.
We have to be specific about it because we haven't decided if it was the standalone.
Yes. It's picking up.
I think that's.
And remember to add the amendment in the edit in the first resolve to capture Julianne's request about the risk benefit analysis, please.
We talked.
And then you want to add when you say about the training?
Well, I think we could leave where it goes later, until later.
We can pick that up later.
Okay, you said something about the first.
Yeah.
And give it a last one.
Oh, yeah, I'll get rid of that. I'm gonna cut and paste. I'm gonna make sure I capture it.
Where's Julian's request?
Well, to incorporate, the one thing that was included in the staff report that was not incorporated was the discussion of California graders.
Oh, yeah, okay.
So while she's working, so the idea on the exact form of the California specific component would be decided later. So once we know the topics, and staff can get back to us with the
Right.
kind of a time schedule. And we should have time to drop it into the training as soon as we go to the next gen. And then how soon it can be, if we decide it wants to be like an afternoon component of the next gen exam, you know, we'll have to wait 2 years, but we'll get to that eventually.
Yes, and we don't know what the court will do anyway.
Or it's also possible that at some point the legislature may be happy with us and lower the 2-year requirement. Because we have effectively telegraphed what the topics are going to be. We'll see.
Let's just get through this. Get through our next item.
Okay, it includes Julianne's in the first resolve, thank you.
And then Paul's. Sorry, Member Kramer's addition is in the final further resolved.
I'll go ahead and read that aloud. Further resolved that the Committee of Bar Examiners direct staff, oh no, it's, so it's this last two, right? Further resolved that the Committee of Bar Examiners, now having considered and adopted the risk-benefit analysis as required by California Rules of Court, makes a final recommendation to the Board of Trustees for their review and approval that the next-gen UBE with a California component be administered as the bar exam beginning in July 2028, and that this recommendation be advanced to the Supreme Court for its approval. And it is further resolved that the Committee of Bar Examiners direct staff to seek direction from the California Supreme Court on which subjects and skills should be tested on a California-specific component to be added to the next-gen UBE and thereafter for staff to develop a California-specific component consistent with that direction. My only, we know that a California component cannot be administered as part of the bar exam beginning in July 2028. So that's my one concern about that language.
Yeah, I would just delete the reference to the California component in that paragraph because that it's coming as telegraphed by the next paragraph.
So it's just that the next gen UBE be administered as the bar exam beginning in July 2028. And then the next paragraph talks about developing the California component.
Correct. Yeah.
So that's my motion.
Is there a second?
Sorry, there's a delay.
This is Michael. I will second Paul's motion.
Okay, thank you. We're trying to get it finalized so we can look at it one more time.
Did someone delete it? That was that was Josh's motion. It was just here, and now it's disappeared.
Jean, can you put it in again?
great question. And one document. Oh, it is that paragraph though. That's looked as like a strikeout. Struck out. But I don't know where the second part is. Oh, that's not it.
Tabling this for a few minutes. While they work on it. Doing Cody's thing.
Should we
Can we-
let you do that and we move to 5.1
Yeah,
while
let's-
you're doing that?
I'm going to table this. All right. Everybody, we're going to table this for a few minutes while they work on the final language. And let's move on to 5.1, Cody
And Tara.
and Tara.
Yeah, thank you so much. And oh, perfect. I was about to share my screen. Then why don't you kick us off?
You got about 5 minutes. So,
We'll go quickly. Let me know if you can't hear me, please. So I think as our chair alluded to earlier, the release of results for the February bar exam right now are scheduled to come out on May 1st, no later than 6 p.m. Part of the grading item that you'll look at earlier will allow some flexibility on the time that we're going to release that. And as you heard earlier from Lisa Chavez, we had 4,408 applicants complete the exam, so we're still finishing up that grading so we can release on time. And then going to, oh, it's not doing it correctly. Let's see. There we go. Okay. Next is the July bar exam. Let's see, I had updated numbers. So as of today, we had just under 6,500 applicants who applied. It was 6,487. And we're up to 366 of those applicants applied with fee waivers. So we do expect this to be a little bit of a larger exam just because this is the last exam. Those from the February 2025 exam can use their fee waiver, as well as those eligible for the adjustment from the November exam can apply it. And then the application will stay open until June 1st. And we just wanted to give you a quick update on the seats since we do have a larger number of applicants who have applied at this point. So back in July of 2024, we only had 4,600 or so applicants around this time when these numbers were pulled, not comparing it to last year since we had opened that application late. We do still have seats available though, both in Northern and Southern California. This morning, Southern California had over 100 seats. Those numbers will continue to adjust as we move applicants with testing accommodations out of the regular sites into the testing accommodation sites. And then we also have 18% of the total seats at each of the standard sites are held for our immediate repeaters. So anybody who took the February exam and decides to sit for July, those seats will be available as soon as that application opens. Okay. And then we also have our June 2026 first year law students exam. So this will be administered on June 23rd, 2026. It will be administered at Prometric test centers and remotely. So again, for this exam, the test centers are the default. Only those who live a significant distance from a test center are approved to test remotely, and it's a small percent of our applicants. As of this morning, we had 202 applications, which is on par with the number of applicants for last year. And this one will be open until May 15th. Any questions before I pass it over to Cody?
Okay, Cody?
Yeah, just wanted to give a quick update on our recruitment of our content validation panelists and subject matter experts for any possible review of bar exam question development. We have now closed our second solicitation. This was launched following the Supreme Court's approval of a final recruitment and selection policy. We had a really great response. We had about 500 applications received just in this second solicitation alone. At the time that we had posted this presentation, we had we had selected and started to run a first cohort of panelists through our procurement process to get agreements finalized. And we had a second cohort of panelists that were under review by our chair and vice chair. I'm happy to say they have completed their review. So both the entire set of selected content validation panelists have been contacted, and we are getting them onboarded for what we hope to be our first panels in May 2026. There's still some kind of internal policy development going on to make sure that the process is really well defined and airtight, but we're really well on our way towards beginning to review the multiple choice and essay questions that are in the bank for any possible future exam. Moving on, I wanted to provide an update from some recent stakeholder engagement. First, I wanted to point out some discussions from our CSBARS meeting just 2 days ago on Wednesday. The committee, or the, CSBARS started to discuss 2 agenda items that will likely be on the CVE's June meeting agenda. First, they started to discuss the unaccredited law school rules. This discussion 2 days ago was really about kind of resetting the stage where we left off in December of 2024 when the proposal, the most recent proposal, was discussed by the Committee of Bar Examiners. So we had a really great discussion then. We anticipate in June having a similar kind of foundation revisiting of that December 2024 proposal at the next CBE meeting. And then, of course, we'll bring some feedback from that CSBARS discussion. CSBARS also started to discuss an item that's on the CBE work plan, which is whether or not to establish kind of targets for our law school performance metrics that are reported in our annual law school performance report. We'll be bringing that to the CBE in June, again, with some of the feedback from CSBARS. I wanted to point these out just because last meeting we talked about closing or improving the feedback loop between CSBARS and CBE. And I think we're really getting a really great cadence and, really have a good loop established with regard to meetings, bringing updates, and then, kind of having iterative discussions. And then lastly, we had our quarterly deans meeting on Tuesday. It's a very busy week for us as far as meetings are concerned. And so we now have these quarterly deans meetings where we meet separately with the ABA, the CALs, and the unaccredited law schools to discuss important topics. This time around, we discuss, of course, the future bar exam options. We revisited the proposal to require AI courses at California accredited and unaccredited law schools. But we also brought in the ABA schools. We wanted to get a sense of what they're doing on their campuses, and we heard about some interesting programming. We also updated them on the recently approved testing accommodation rules and how that is being reflected in our procedures. And this is an interesting topic because this was the most requested topic from our law schools. So we each meeting asked them to help us agendize the next meeting. Testing accommodations was right there at the top. And then lastly, we had an interesting discussion about the exam statistics we publish after each bar exam and first year law students exam. And then we got some really helpful feedback. We're working on kind of a facelift, I think is how Lisa described it. We're improving how we publish the statistics so that the public can understand them better. And then our law school stakeholders gave us some great feedback that we're implementing as well. I think that's the end of the presentation.
Thank you. Thanks, Cody. Thank you, Tara. Yeah. Kareem, go ahead.
Yes, Cody, thank you for that summation. I had a question on CSBARS. We used to have them come present, and I believe there was like a newsletter that was intended for distribution. Do you know the status of that?
The newsletter, I can't recall what that was referring to, but I can speak to having the members present. We have kind of more recently and informally had the chairs come and bring like reports to the committee. If you recall at the last meeting when we were updating the terms and other elements of CSBAR's kind of structure, one of the things that the committee adopted was a recommendation that the chair that we like kind of slot several opportunities in the year for the chair to come and provide a report. So kind of like formalize that instead of an informal practice. So you should anticipate that we'll have the chair come speak to the committee soon.
Okay, thank you so much. Appreciate it.
Thank you. Anything further? Okay, thank you, guys. Great report. Gene? We're ready. All right, so let's go back to 4.7. Post a resolution.
So we've updated the last two further resolves to capture Member Kramer's recommendations here. I've highlighted some language just so you can see what changes were made while we were taking up the other items. So I can just read through that if that's helpful to everybody. Further resolved that the Committee of Bar Examiners, now having considered and adopted the risk-benefit analysis as required by California Rules of Court, makes a final recommendation to the Board of Trustees for their review and approval that the next-gen UBE without a California-specific component be administered as the bar exam beginning in July 2028 and until such time as a California-specific component is developed, and that this recommendation be advanced to the Supreme Court for its approval. And it is further resolved that the Committee of Bar Examiners directs staff, as part of submitting this recommendation to the board and court, to seek direction from the California Supreme Court on which subjects and skills should be tested on a California-specific component to be added to the next-gen UBE, and thereafter for staff to develop a California-specific component consistent with that direction to be delivered at the earliest opportunity.
Okay. Is there a motion? Paul? Well, hold on. Is there a motion?
There was a motion by Paul and a second by Dr. Cal.
That's right. It's already been moved and seconded. So, Julia?
Does that include the amendment for the greater statements?
Yes, it is in
Is
there.
there?
So.
Okay. Just make sure.
Any other discussion? Devin, please call the roll.
Bolton?
Yes.
Burns not present. Cow?
Yes.
Gongora?
No.
Kaplan not present. Kramer?
Yes.
Lawrence?
Yes.
Lee? Misiwala not present. Montgomery?
No.
Reed not present. Reyes?
Yes.
Reyna?
Yes.
Silva Guzman?
No.
Smith?
No.
Yokelson?
Yes.
With 8 ayes and 0 nays, the motion carries.
Okay.
Three.
3 or
nays?
4 nays.
With 8 ayes and 4 nays, the motion carries. No? Yes?
There were 4
What
nays.
did I say?
You said zero.
You said zero
Sorry,
nays.
sorry.
Could you just say it one more time for
Yes.
the record, Devin? Thank you.
With 8 ayes and 4 nays, the motion carries.
Okay. Moving on, we have a special set now.
Can I just say?
Yeah.
It's been a year. We've been talking about this since May of 2022. And this has been a lot of conversation. When I first was talking with Laura about how we would present today, I said, I think I've said all the words. Like, I don't have anything more to say because we really have delved into this quite a bit. And I just want to thank you for your incredible attention and thoughtfulness on this matter as we've talked about it over the many meetings. I think we have, I'm really pleased with the final risk benefit analysis, and it's been your direction that really helped us get to this point. So I think you should all be pleased about sort of having sort of come full circle after the February 2025 exam. So I just want you to sort of think about all the work that you've done, and thank you for that.
And I want to thank Josh, even though it may sound like it didn't, your resolution didn't pass, but it provoked a really thoughtful discussion and getting us to this point. And who knows what the Board of Trustees will do with this.
I want to thank
in the
Paul for
court.
admitting that he uses stone tablets to study.
And I join in that.
It really brings out
All right, let's move on. Item 4.8, recommendation to the Board of Trustees to adopt changes to the grading policies for the California bar examination. I understand we have Chad Buckley here to present.
Yes, I'm going to start and then I'll send it over. Devin or Sharon, can I get promoted? So I thank you. I can share my screen. Oh, and promote Chad, of course.
And then promote Chad Buckley.
There he is.
Perfect.
Okay, great. Thank you. So the staff recommendation today is to update the policy regarding the release of exam results, allowing staff to release individual results earlier in the day rather than releasing at 6 p.m. at night, and then posting the public pass list on a business day as opposed to a Sunday. However, due to the competing IT priorities related to the numerous ongoing rule revisions, staff is recommending to maintain the majority of current grading policies as they are. And with that, I want to show a PowerPoint presentation. Okay, so I want to extend my gratitude to the Office of Research and Statistics for analyzing exam data from the past 5 years and conducting some simulations to evaluate how different grading policies might impact overall pass rates. When the grading policies were last presented to this committee in March, members requested additional data on the effects of alternate grading approaches, and today I will present that data. And as mentioned, Chad Buckendahl is also here. He is the CBE psychometrician, and he can address any questions you all may have regarding our grading policies. There is a lot of data on, a lot of numbers on these slides, so I did highlight some of the areas, the numbers that I will be speaking about. This slide shows the February exam over the last 5 years, so February 2021 through February 2025. You are going to see 2 rows. You will see the average pass rate for all of those February exams. But on the bottom column, you're actually going to also see the average pass rate without the February 2025 bar exam. As you remember, the February 2025 bar exam, the applicants experienced challenges. And so this committee went ahead and gave remedies, additional points in some cases. So we ran the data that includes the February 2025 exam. Again, that pass rate right here is 57%, but we also removed that February exam to get a true and more accurate of what our pass rate typically is. So on average, the first read February pass rate is on average, without that February exam, about 35% or 39% if you put in the February 2025 bar exam. Approximately 474, 435 applicants total go into second read. That's about 11 or 12% of our total applicant population that goes into the second read. And from there, of that approximately 2% to 3% pass out of that second read. This slide is a very similar slide, but this is the July bar exam pass rates. You will see an average of 8,173 candidates will sit for a July bar exam. Approximately 52% of them will pass out of first read. And you will notice about 9% of those applicants go into second read. And ultimately, just like in February, approximately 2% of those applicants that go to second read will pass out of second read. This slide examines the point discrepancies between first read and second read. With this grid, you can see that point discrepancies of 5 points or less, about 80% of our applicants experience a point discrepancy of 0 points or 5 points. Nearly 96% are within 10 points. Read 1 and Read 2 are within 10 points of each other, which demonstrates strong greater calibration and consistencies. In this slide, we ran some simulations analyzing how different grading policies would affect pass rates for applicants that do make it into the second read. Here is our actual, this is our actual grading policies as they exist today. On average, about 600 applicants go into second read. Out of those 610 applicants, approximately 100 will pass, and that's about a 16% increase in the pass rate. Let's see, simulation 1, here, we ran as using the higher of the two grades from Read 1 and Read 2. We did maintain our normal rounding policy that, if you all remember, at 1389.001 in second read, we actually round that up to 1390, making it a passing score. You can see that the pass rating jumps to 68% if we use the higher grade. It falls just slightly down to 66% if we, again, use the highest score between Read 1 and Read 2, but we don't actually round, so that we keep the true passing score at 1390. Here in simulation 2A and 2B, we did not necessarily use the higher grade, but the second grade, Read 2, could not be lower than the first read. So you can see even that pass rate there, as opposed to the 100, average of 100 people passing during our current policy, 244 people would pass if we used the simulation 2, which is for the second read not to go lower than first read. That's about a 40% pass rate, and that's if we were still rounding at 1389.001. And of course, 2B is if we do not round at 1389.001 in second read. That is if we have the score of 1390 as a true score. About 37% of our applicants would pass out of second read. And this last slide here, this displays data from the last 11 exam administrations and showing how many applicants actually would not have passed second read if we didn't round. You will see in the last 11 exam administrations, no one has fallen within the 1389.001 up to 1390 in second read, other than 11 applicants through the February 2025. They benefited from the rounding. At this time, I want to again introduce Dr. Chad Buckendahl, and he can assist answering any questions the committee may have regarding the grading policies.
Good afternoon, Chad. Paul, you've got a question?
Yeah, Chad, could you just comment for a moment about your position on averaging? I think it was in the staff report, but I think it would be good to reiterate it.
Yes, Mr. Kramer. So thanks for the question, and thanks to the committee for the invitation today. Yeah, so generally, when you have two observed scores of, in this case, an applicant's performance on a question, when those scores differ, assuming that both of those independent observations were based on people who were qualified, trained, calibrated, to systematically select either the higher or the lower score introduces essentially bias, and you're capitalizing on random error. So the best indicator of a true score in that instance is sort of the midpoint or the average between those two.
And do you have any thoughts about the rounding up?
Yeah, in terms of the rounding, I probably go back to my mathematical background on this, and I mean, I tend to think that when you're reporting at a scale score of a whole number, in order to sort of cross the midpoint between two scale score values, in my mind, rounding would say if you are at a 1389.50 or greater, then that would round up. Like the next closest number is 1390. If you're below that, the next closest number is a 1389. So the 13.001 or anything just slightly above 1389 is not it's not mathematically closer to the next highest scale score. It's closer to the 1389 in that case.
But is there any reason to round when you have just a integer cut score?
No, I mean, you can truncate and say any value that does not achieve at least the threshold of 1390 doesn't meet the defined cut score by policy. I think the only, again, sort of mathematical rationale is we know that at sort of each component, there is statistical error, right? There's uncertainty around the stability of any of those numbers. And so that's why I'd probably use like a mathematical rounding rule. But there are several programs probably inside and outside of the legal profession that would simply truncate and say that, again, if you don't hit that minimum cut, you haven't met the standard.
What does the national conference do on the UBE and then on the next gen?
I honestly, I don't know what their internal policy is with respect to rounding. I do know they use item response theory to create the scale values. And so that's on a logit scale, which, is going to be to several decimal points. But I don't know what their rounding rule is when it comes to the actual report of the scale score.
And I would expect that the ultimate decision would belong to each jurisdiction, how they want to round.
Okay, well, that's a question I have ultimately. Don't answer it today, but is to what extent can we make those decisions independently? Because if there's portability, it would seem that everyone should be using the same standards of that nature. Anyway, we can talk about that later. Thank you.
Donna explained to me a while ago the reason for rounding on the final score was we don't want anybody to fail for less than a point. However, there's a built-in issue there because you don't go to second read if you don't achieve what if there's no rounding to get you to second read, but there is rounding to get you to the final score. So the people, in other words, it benefits the people who've been through second read. Yeah. Is that correct?
Yeah, so I think the issue is the use of the average and the different ways of rounding. So if after first read you have anything below a 1390, right. In other words, if you have a 1389.999, you go to second read. Now, Christina showed a bar chart, which is, as one of our researchers had said, the best bell curve she'd ever seen, that showed there really isn't a lot of variation in the scores between the first read graders and the second graders. That the vast majority is 5 points or 10 points. But you could, right, under this scenario, you have a 1389.999. You go to second read, and then you get sort of 10-point difference. And so you've got overall now a 1379.999. The average of that would be a 1385. So if you'd gotten that 1389.999 after second read, you would pass, but because you got it after first read, you didn't. So that's
And you go down.
That's the one oddity between how those two policies, the averaging and the difference in the rounding, it creates that odd situation. It can occur. It certainly does not occur with any real magnitude, but it is a possibility. And so that's why we've been having this discussion with you, just to make sure that you're aware of that odd result in that circumstance.
And except for February, rounding hasn't benefited anyone. There was only those 11 people on February 25. But the bottom line is that IT can't, if we wanted to recommend changes, IT doesn't have the bandwidth to make them for some period of time, correct?
So that, Christina, you let me read. Yeah, I was just going to say, so that is correct. So we do have numerous rule revisions going on right now that just takes precedence. We would probably be able to get to it within the next 9 to 10 months, maybe year. And then, of course, we may have a different, or we will have a different exam in 2 years regardless.
Yeah, well, we will have the time between now and next gen that the policy will apply to for sure. I'm ready to make a motion if there's no more.
So
Let's hear from others.
Unless anybody else wants to talk. If I may direct everyone to attachment A in the agenda. It is a list of all of our current grading policies, and knowing that this committee spirited discussion was mostly around rounding and phase grading. I did write a couple of different recommendations depending on what the committee wanted to do. That would be taking the higher score, averaging as we have been, or making sure that the second read grade is not lower than the first. And then for the rounding portion, I did write some different recommendations, again, depending on what the committee would like to do, whether we want to continue to round as we always have in second read at 1389, whether we want to not round at all. Is that both of them?
But again, Christina's recommendation that she started her presentation with is that the only thing that is changed is the policy around release of results to give us greater flexibility to release earlier, and also to make the release of the public pass list not on Sunday, but on the business day immediately following the release of the results to the applicants. Her staff recommendation is that the other items, rounding, second read, averaging versus best of, that we stick with current. And so that would just be, based on her direction, she would just strip out the other alternatives in that policy.
What's the reason for releasing them on Monday instead of a Sunday?
Currently, right now, we release on Sunday, and that requires someone, a staff member, to work on a Sunday at 5 o'clock, getting the results ready to actually release at 6 a.m. So we are just recommending to move that to a Monday, which is a regular business day.
And not just the public pass list, the applicants won't be, they already have.
No, I know the applicants too, but what I'm thinking about is we come to work on Monday. We have several people who've taken the exam. Everybody is tippy-toeing around it. And for me, at least, I'm better off knowing on Sunday night, so I know what not to do on Monday. I don't know if that's a concern. anybody else, but I'd kind of like to know. So I'll throw that out there.
And we have been making some internal process changes to reduce the requirements that would have an expectation that our staff are working after hours or on weekends. And we had a number of the bar exam application, I think, used to open at 12:01 a.m. And we've said, no, we're stopping that. And so now it opens at 8 a.m. on the day of. And so we've been trying to make these process changes so that we are not creating these requirements for staff to be working outside of regular hours. And although most of the posting of the public pass list is automated, there is staff involvement. And so that is one that at the staff level, we feel very strongly that we would like to change that policy and make sure that we are not mandating staff work on the weekend to post that public list.
The applicants get it Friday night, correct? Okay. What about, what time would it be on the Monday?
That committee can say what time they'd like. I believe in the agenda, I wrote it for 8 a.m.
Yeah, okay.
It's approximately 9 a.m. right now,
Yeah.
so we could change that.
Does that mean someone has to come in early, though?
Not typically. IT typically has earlier hours, so they're usually here about 7 a.m. I gave them an hour to, settle in and get everything queued up.
Okay.
Okay. All right. Paul, did you have a motion?
Yeah, maybe Christina can help me pick the right set, but what I would like to do is keep averaging, but when we can, remove the rounding up, or at least change it to 89.5, so it's mathematical rounding and not, but let's just eliminate the rounding. Because effectively, we've reduced the cut score to within 1,000th of 1389, and I don't think that's right. That's probably, I don't even know if the court knows about this.
They do.
Okay, have they said anything?
So the conversation that I had with our Supreme Court liaison was, when I learned of this, I had this conversation with him back about a year ago. And his reaction was, oh, well, I would think it would be more like 1389.5 for both of them, that the rounding would be consistent and that it would be at the 0.5. But he did not express strong concern in that conversation about the way it was currently being processed.
Okay, I'm gonna change my mind. Well, I was shocked to hear about it. It affects so few people that it's not worth messing with. So I will just go with the staff recommendation to leave things as they are.
With the exception of the release to the public of the bar.
Yeah, which I presume is included in the motion.
Yeah.
Thank you. So
Okay.
it's a release for 4 p.m. on Friday at this point, although there is some conditioning in there as well, that if we were earlier, maybe a week early, that the CBE would be amendable to us releasing results when they're ready and not necessarily having to wait an extra week just because that's.
So that's in there too?
That is in there.
Okay, yeah, that's great. Why should
Right.
people have to wait?
Right.
And then I just also, last thing, want to point out the reconsideration policy. So ultimately in the agenda that was written, I recommended the reconsideration policy completely disappear, just because we haven't had a reconsideration policy or a reconsideration request that we've needed to bring to a committee in so long. However, I'm going to hold off on making that, making the recommendation that the reconsideration policy disappear, perhaps until we get into the new bar exam. So I did do some redline. Really, the redlining here is just some wordsmith changes. And so the policy itself is not any different. It's just worded a little bit differently. Reconsideration request, you cannot say, hey, I disagree with how we graded. I disagree because I didn't get to second read. But if there is a clerical error, for example, that your answer did not properly get graded because it was stuck in an envelope because you switched from laptop to handwriting, something along that lines, we will still go ahead and grade that, so nothing policy-wise will be changing.
That's my motion, as she said.
Second, please. Second, moved by Kramer, seconded by Bolton. Devin, call the roll.
Bolton? Burns, not present. Cow?
Yes.
Gongora? Not present. Kaplan, not present. Kramer?
Yes.
Lawrence?
Yes.
Lee? Masiwala, not present. Montgomery, not present. Reed, not present. Reyes?
Yes.
Reyna?
Yes.
Silva Guzman?
Yes.
Smith?
Yes.
Yokelson?
Yes.
With 10 ayes and 0 nays, the motion carries.
Excellent. All right. That concludes our open agenda. We need to move in the close. I'm sorry, folks, we need to take a 5-minute break. It's 3:33. We're coming back at 3:40. Come heck or high water in closed session. So at this time, the committee will move in the closed session pursuant to Business and Profession Code Section 6026.7 C3 and 4 and Government Code Sections 11126 C1. Let's go into closed session and we'll convene that session in about 5 minutes. Thank you, everybody.
Whoa.
Yeah. Yeah. Ants in the pants, you know?
You went one.
We're live. We're live, guys. Thank you. We're back in open session. There is no reportable action. Meeting business has been concluded. Is there anything further? No? Okay. This meeting is recessed until Saturday, April 18th, with the only item on the agenda being closed session item 3.3, approval of the written questions for inclusion on the July 2026 California bar examination. Thank you, everybody. We'll see you in the morning. Thank you.